I declare open this hearing of the Senate Finance and Public Administration References Committee into the operation and appropriateness of the superannuation and pension schemes for current and former members of the Australian Defence Force. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via video conference and in person. I'm Chair of the References Committee, Senator Dave Sharma, and I'm joining by video conference. I understand that Senator Grogan is there in person and that other senators, including Senators Dowling and Senator Lambie, who move this inquiry, are joining us by video conference. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request that evidence be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution, however, does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is being made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised, and a copy of this order is available from the Secretariat. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect, and I remind committee members and witnesses who are appearing via video conference and who are not speak to please mute their microphones. I now welcome a representative of the DFRBB commutation campaign. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacities in which you appear today?
Peter Williamson.
And your capacity, Mr Williamson?
A retired superannuant addressing Mr Ken Stone's submission to your inquiry.
Thank you, Mr Williamson. And do you have any colleagues there with you? I'm sorry, I can't see from where I'm sitting.
I have my daughter, but there are colleagues behind me, gentlemen that I've only just met this morning.
Okay, well, thanks, Mr Williamson. Mr Williamson, would you like to make a short opening statement? And if so, please do so, and then at the conclusion of your remarks, the committee members will be invited to ask questions.
Okay. I have made a submission, which you will all have. Sadly, this morning, the gentlemen behind me have somewhat taken the wind out of my sails in regarding my particular submission. However, there are still issues that are extant, and I will address those. Now, I wish to bring to your attention the commutation factor and a multiplier. This issue, amongst others, is detailed in submissions to your inquiry by Mr Ken Stone. Ken is an independent advocate acting on behalf of 4,000 superannuants seeking pension justice. DFRDB recipients have never been informed of the existence of commutation factor or the multiplier. CFM, I believe, is applied to all Commonwealth Government superannuants. Only DFRDB recipients have been excluded from this CFM. Ken has been pursuing an explanation as to why this exclusion exists. Any information that has been provided to him and available to me has proved to be inaccurate and in some cases untrue. We believe the action is simply a blocking action. Ignore this long enough and the issue will cease to exist. The age demographic of people affected is getting up into over the 80s and the late 70s. I make no comment about the current system subsequent to the DFRDB system. I'm not aware of what their conditions are. Now, I did believe that commutation factor multiple was applied to all public servant pensions. I'm now wondering whether these gentlemen have informed me that that is not the case. So I won't go into facts and figures as per my submission, but what I do want to say is that, pardon me, this issue is not resolved. I'm sure there'd be some 4,000 of Ken's followers who do or don't believe in commutation factor and multiple. Others possibly don't. But the issue has never been clearly addressed and superannuants told, are they or aren't they entitled to this? Mainly because there has not been a truly independent body who can make that call. Anybody who's in the loop is either a public servant, well, mostly public servants, or politicians. Nobody seems to want to tell us, is it true or isn't it? I'm absolutely certain that if superannuants in our application, if they are informed that of the situation and notified basically individually, which rarely happens, I might add, then they will be happy to accept the decision. But while ever it remains like this, it just leaves a bad taste in everybody's mouth. So that's about my submission. There are a few other factors, but I'm open to questions.
Thanks very much, Mr Williamson, for your opening statement. I might ask Senator Lambie if she'd like to lead off on the questions.
Good morning, Chair. Can you hear me?
Yes, we can, Senator Lambie.
Oh, great. Great. That's working. Good morning.
Good morning.
The commutation. Do you want to go in? Do you want to explain that a little more about the commutation and what it's been doing? And I believe that maybe the boys behind you will want Mr. Hislop and them. But do you want to tell us a little bit more about the commutation, what it does? Right. Can you do that from where you are?
Yes, I can.
Right.
Well, the commutation was the amount 4 times our annual retirement salary that we could commute, called commutation. And as a result of that, we took a reduced pension. Some believe for life, others believe that reduced pension should have been restored to the full amount of our salary at retirement. Let me get this right. At forget the term.
At 65?
Life expectancy factor.
Right.
And that was the original inquiry by Ken Stone into why wasn't that pension reinstated to full value at that time. He believed that by that time we had repaid in full our commutation to the Commonwealth. And there was no reason why we shouldn't have our pension reinstated to the full amount. Now, commutation factor is a different thing altogether, and it only became evident when the 2019 Manthorpe submission was made available to us. Mr Manthorpe said that he engaged the Australian Government Actuary and I think KPMG to have financial comment upon what he was investigating. But that was the only mention in his final report. He made no mention whatsoever of commutation factor and how did it apply. So it's not the commutation that's in contention, it is the commutation factor, and is it applicable to us? If it is, let's have it paid. If it's not, let everybody be clearly notified as to why it is not. Till that's done, there's not justice for or closure for DFRDB recipients.
Okay, so you're right, you're a DFRDB. You're in this situation now, are you?
Yes, yep.
Okay, so do you want to tell the committee on what that looks like now and the losses the losses that you made due to that?
Okay, sure. Now, at the outset, I must say it is my belief that Commonwealth and state and many industry superannuation schemes apply this commutation factor in various ways, and some schemes also have side benefits, education facilities for their superannuants' children. There's a range of things. But my understanding is that, and I've got this figure wrong, that the commutation factor in our case multiplier could be the number 20. This is as stated by the Australian Government Actuary. Now, my understanding is you multiply that by your 1 year's annual pension. So if we take that in my case, I've got the figures wrong here, but it will come out to about $150,000. Now, that's in 1982 figures when I left the Navy. Now, we've not had the opportunity to invest or use or do anything because that money was never paid to us. Now, I understand that the idea of it was to allow for the decline of your pension over time, cost of living, devaluation of the dollar's value for purchasing power, etc., etc. Now, if that was applied to public servants, then they have no further claim on the system, that's it. And there would be no need for this committee if it was found that we were entitled, because you've been given that money. How you invest it, what you do with it, is entirely up to you. But in today's dollar values, it is one hell of a lot of money. Does that explain?
Yeah. So what I'm trying to work out is how much do you believe that you've missed out because of the system?
Well, at the very start, in multiplying 20 to 22, be 160 at 1982 values. That would have been $160,000. Now, if we scale that up to today's values, who knows what it is? But you know, if it's true, I've been and every other superannuant, DFRDB superannuant, we have been denied that money from the jump. We would have no further claim on the Commonwealth if that money was paid to us in the first place.
Jackie, Chair, do you mind if I ask a follow-up question there?
Yeah, go.
So is that pension, does it have a CPI increase, or is it?
Ours does, yes, and the gentleman behind me will address that issue. It does have a CPI increase, yes.
But that doesn't... So the idea of the of this commutation factor,
Yep.
multiple, would that have been like a one-off payment at a certain point or a certain milestone point?
At retirement.
At the point of retirement?
Yeah, I believe, as I say, I'm not certain of these facts because I'm relying mainly on one source, but my understanding is that would have been paid at the time that you received your DFRDB. And possibly the pension wouldn't have been indexed or anything else because you have collected your money, you take it, you go away, you spend it on fast horses or slow horses and fast women or whatever you want to do. Or you invest it so you can keep abreast of the cost of living and everything else. Now, we do get CPI. The CPI wasn't applied to the start when this scheme started, and these gentlemen behind me can address that issue. It was later introduced and not back paid to when it first started, and we do now have a CPI factor in there.
Yeah, because I was under the impression it was indexed twice a year.
That's correct.
Yeah.
Yeah, that's correct.
Yep. Okay. Thank you. Sorry, Jackie. Back to you.
Senator Lambie.
Okay, so can we just go back a step? So you got your DFRDB, that's the deal you signed up with, your defined benefits
Yes, yep,
scheme.
yep.
All right. So tell me what the commutation factor. So when you got your DFRDB, okay, you decided there was some deal done back then with the government. What was that initial deal with your DFRDB?
Okay, the DFRDB scheme, and the one that I signed off under was introduced in 1972, and we contributed to that scheme, as did the government, until we had done 20 years' service. Now, there's a little bit of variation in there that I can't exactly go into, because prior to the DFRDB scheme of 1972, there was a DFRB scheme, and the DFRDB scheme replaced that scheme.
Okay.
And all of my service, here again I'm not quite certain, but certainly the bulk of my service, I was under the DFRDB scheme.
Oh, so you have a mixture.
Well,
Of the
no,
old
because
scheme. No, you changed. It was a straight changeover.
yes, it was. We were given the
Okay.
option to change over. Correct. Yep.
Okay. And did most change over?
Oh yeah.
Can you recall they did? Okay.
well,
so the
I assume they
wasn't-
would have.
It was compulsory.
Sorry.
My notes, it was a compulsory move from the.
Okay.
Oh, was it? Okay. Right. Yep.
Okay. So that was a compulsory move. I'm sure the gentleman behind you will probably know more about that older
He
scheme.
certainly will.
but-
Yep.
Yeah, that's okay. So from that, do you mind if I ask how old you are?
Me, 80.
Yeah.
80 next month.
Okay, so I have to say you look very sprightly there.
Thank you.
You're
So do the gents
welcome.
behind me, I might add. They've all lived clean
There are
lives.
those gents behind you. Yeah. Okay, so what do you get anything now? Like, what does it look like now for you at that age? On top of do you get any age pension? Is it just your
Yes,
DFRDB
no.
scheme there? What does it go?
I get DFRDB, and I also get a top-up pension.
Top up.
I believe,
Okay.
yeah, from the Commonwealth.
Okay, so what's your DFRDB pay you on average a fortnight?
Okay, I'll have to take another approach. The combined payment is around $2,000 a fortnight.
Okay.
And I didn't anticipate I would be asked these questions.
That's okay.
So I
I'm
can't
just-
break that down into the two sections.
Okay, but you're still getting topped up with the age pension.
Yes.
Okay. So, I suppose I'll have to wait for the gentleman behind you. I'm just wondering what that should really be worth these days of what you're getting as part of your DFRDB, because you've missed out on that initial, what are you saying? It was worth 160,000 or 150,000 back then, that extra on top.
Well, the extra on top may not have been applicable had we been given that money in the first place.
Okay.
I'm not sure about that. I might make a little comment here that I receive notification from two different organisations. One is DFRDB and one is, I believe, from the Commonwealth. And they say, right, there's been a CPI increase, so you're getting an increase. Good, so I get an increase. The next thing, I get a letter from DFRDB, I think it is, I'm not sure, saying, you've just had a CPI increase, so now we're going to decrease your payment from this other source, which means that this full CPI, as I said, is not actually being passed on to me.
Oh, okay, so it's coming out of your pension. So it's substituting because you
Yeah, because I've already got some income.
And then they're taken out of your age pension.
Yeah. I did inquire of DFRDB and I did inquire of somebody else. Nobody really, only on the phone, but there was a fair bit of nobody really wanted to claim ownership of the issue, and I didn't pursue it at that time. It wasn't important. Well, it is important, but not that important.
Okay, and I have one final question for you. What is the outcome that you'd like to see? What is the end result here that would help you guys out that are stuck in this? I don't even know what you call it because it just seems
limbo,
to be limbo,
basically. Yep.
Yeah. So what is your outcome? Like, what do you want to see? What do you believe needs to be fixed with it from where you are?
Okay. I believe that if that commutation factor multiple is payable, it should be paid. Furthermore, it should be paid in today's dollar values, not 1982 dollar values. That's the ideal situation, I guess. But more importantly, if it is not payable, we need a clear explanation of why it's not payable, and that needs to be transmitted to the DFRDB members who have been wondering what this matter is all about. I'm not saying we're entitled to it, I'm saying that would be the ideal outcome.
Yeah, you just want to make some sense out of it.
I just want to know.
Yeah.
If it's payable, it should be paid. If it's not payable, let's have it out in the open and everybody told openly and plainly why it's not paid and notified.
Okay. I have no final questions, Chair. Thank you so much. Thank you from your lived experience.
Thank you, Senator Lambie. Senator Grogan or Senator Dowling, have you got questions for this witness?
Thank you, Chair. Thank you for coming and spending time with us this morning. Really appreciate it. So, do you know anyone who did receive this the factor multiplier?
No.
Okay. But the idea being that at the point that you retired from the forces, you would be paid a lump sum effectively?
No, we were never, the DFRDB recipients were never part of that, the commutation factor multiple. It just didn't, we knew nothing about it. What we received was commutation, which
was 4 times.
4 years our retirement salary and then a reduced pension, we thought until
the lifetime
expectancy or whatever, and then it should revert, but it didn't. And that was what the original submission and inquiry was about by Ken Stone. And possibly, others would have submitted to that inquiry as well. But the findings, there's a fair bit of contention about the findings and the independence of, well, Mr Manthorpe for a start, but ranging down through the line. Nearly everybody involved in the decision-making process is a public servant. And there's nothing wrong with that, except Mr Manthorpe is a public, or was a public servant, and he was appointed as a Commonwealth Government Ombudsman by the government. Now, I just cannot believe how Mr Manthorpe can possibly give an unbiased finding. That the a Commonwealth Government paid ombudsman, or any paid ombudsman by the organisation he's representing, to my mind, that's an oxymoron. You can't have independence. His decision has to be influenced by those who are paying his salary.
I think we're going to need to do a little bit more research into this.
Sure, yeah.
The commutation factor, because I'm not sure I quite grasp exactly.
Okay.
But also, if it is a thing, why wasn't it paid? Was there a discretionary point? So I'm not clear about that.
Yep.
But I think we need to understand it better. Yeah. Okay. And is this a common, like, I know there's what, 4,000 people in your advocacy group?
That's Ken Stone. He's the advocate and self-appointed, but he claims he's got 4,000 followers. I don't know how active they are. I suspect a lot of them are not. I suspect a lot of them possibly died as well. But I'm certainly a follower. And sorry, your question, I've lost it.
No, I was just wondering how many people were affected by this, whether you had a sense of how many people this was an issue for.
Well, if we go back to say, well, possibly 30,000 people.
Right.
Because the scheme was introduced in 72, but some guys enlisted earlier than that under the old scheme. They transferred across. So I did some facts and figures the other day. I believe the oldest of these people affected would be 87.
Right.
The youngest, I don't know, I'm 80 and these gents behind me are a similar vintage. A lot of the people affected have passed away. Or they may be so ill or mentally incapable these days, Alzheimer's and all those things affect us. Or they may simply say, look, I'm not long for this world, I don't care, I'm alive, I can buy a beer, full stop, that's it. But your question was how many are affected? My guess is possibly still somewhere around 30,000.
Okay.
But don't hold me to those figures. I'm quite happy to try and research that.
Thank you. I really appreciate it. Thank you, Chair.
Okay, thank you.
Senator Dowling, did you have any questions you wish to ask?
No further questions, thank you, Chair.
Okay, thank you. Can I just ask you, Mr Williamson, in your submission to this inquiry, I know you made a submission in the previous Parliament, your request was that the committee refer the operations of the DFRDB scheme to the Australian Prudential Regulatory Authority for a comprehensive and professional investigation of that scheme. Is that still your request to the committee?
No, I think you'll find that was in a letter actually addressed to you by Ken Stone. I didn't request that, and I've not previously appeared before a committee of any sort.
I think it's on page 3 of your submission 21, but I might be mistaken there.
If it helps, the submission is the advocate submission, which is Ken Stone. Mr Williamson's submission is a separate submission.
Separate submission, sorry.
Yeah, so that was from Ken Stone.
Yeah.
not
No,
from
I understand,
me.
Mr. Williams.
Yeah. Okay. Yeah.
But on behalf of the commutation campaign.
Yes. Yeah.
Okay. Thank you. Look, I had no further questions. Senator Lambie, do you have any further questions before we move on to the next witness? I will thank you on behalf.
No, thank you. And just for your information, it was between 40 and 50,000 on that DFRDB. I don't know how many of them are on the commutation, so I'm just trying to find out who got that initial promise and what's going on. So I'll do a bit of study on that, just see what happened early on, okay?
Mm-hmm. Yep.
Well, Mr. Williamson, on behalf of the committee, thank you for appearing today at short notice. You will be given a copy of the transcript of your evidence, and you'll have the opportunity to make any corrections to that should you wish.
Okay. Thank you very much. Thank you.
I now welcome representatives from the Australian Defence Force Retirees Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Senator, could I handle that in my opening?
Actually, no, I'd like to get your names and your capacities before we proceed to an opening statement.
I have that included.
Please.
Just say
My name is James Glenn Hislop. I'm the President of the Australian Defence Force Retirees Association.
Thank you, Mr. Hislop, and your colleagues.
I'm Herbert Ellerbach. I'm the Secretary of the Association.
Yeah, good morning, Senators. Ron Hack, I'm retired RAAF officer, and I'm the Treasurer of the Association.
Good morning, Chair. My name is Clinton McKenzie. I'm an ordinary member of the Association, but part of the research team.
Thank you so much. Mr. Hislop, you're now free to make an opening statement. And at the conclusion of that, I'll invite committee members to ask questions.
Thank you, Senator. Good morning, Chair and Senators. My name is Jim Hislop, President of the Australian Defence Force Retirees Association. I served in the Australian Army since 1954 to 1987. With me are our principal researchers, Herb Ellerbach, Ron Hack, Clinton McKenzie, all former servicemen and all DFRDB recipients. We are all volunteers. Our association represents more than 5,000 members and speaks for some 40,000 surviving DFRD people and 10,000 widows, widowers and dependents. For decades, the truth about the DFRDB scheme has been minimised, distorted and dismissed. Members were promised one thing, delivered another and misled about the difference. That is not perception, it is a documented fact. The JES Committee's intent was clear, a lifetime retirement benefit with real value maintained, commutation, an advanced lump sum with a proportionate offset based on life expectancy, and a widow's annuity fixed at 5/8 of retired pay, discounting commutation. That was the deal, but it is not what the DFRDB Act delivered. In 1974, proportionate became permanent, using life expectancy factors that were already a decade out of date. This created structural bias that penalises those who live longest and those who retired most recently. Partial CPI indexation in 1977 compounded that detriment. Widows, widowers and those who did not commute continue to bear these distortions today. These were not deliberate policy choices, but made without transparency. Defence did not simply administer the scheme, it shaped it, concealed its effects, misrepresented its impact to ministers and Parliament, and provided serving members with information that hid the true consequences. DFRDB members made compulsory, uninvested contributions from their modest military salary and served in conditions that no public servant or parliamentarian is asked to endure. Yet their retirement benefits have been eroded for decades by decisions they were never told about. These harms are not historical, they are current and affect thousands of veterans, many elderly, many struggling. Senators, the question before this committee is whether it will finally acknowledge these facts and act by recommending restoration of historical losses caused by the scheme's inbuilt benefit erosion mechanisms and recalculation of ongoing benefits to reflect adjusted settings. Thank you. We are ready for your questions.
Thank you very much, Mr Hislop, for your opening statement. Senator Lambie, would you like to commence with questions?
Good morning, Mr Hislop. How are you, Jim? You good?
Thank you, Senator Lambie.
Good. Okay. Can you explain something to me? I just want to, so let me get this right. I want to go back. So you were led to believe that if you took a reduced pension, that in return, the full amount that you should have done, I'm just trying to get back to that initial deal, right? So you were paid less of a pension. Where's the commutation? I'm just trying to get my head around that. Because basically you're going to get commutation, you would take a reduced pension and then you would get a payout at the end of it, or a payout at your end of your 20 years or something. Is that correct?
I'll refer that to Mr Ellerbach.
Okay.
So, good morning, Senator. The deal was that when we retired, we received a retirement pay based on the number of years of service. That retirement pay, we were then given an option to take 4 years' worth of that retirement pay as a lump sum. And the ongoing retirement pay would then be reduced on the basis of a life expectancy factor. The life expectancy factor, as Jim mentioned in his opening address, was based around 1960 to 1962 life expectancy. So already for the people who, people like...
Oh, yeah, so what was that? What was that life expectancy back then, guys?
On average, 72 years. On average, age 72 on average.
Okay.
So for males, so it varied depending on what your age was when you retired. So in my case, I was 36 years of age when I left after 20 years service, and my factor was 35.51. Jim's was probably something down around 20 because he was much older.
Okay.
So that generated a reduction of that retirement pay. So an understanding of probably the majority of people was that when they reached that particular life expectancy age, that their benefit would then be restored back to full value because, in effect, they have repaid the amount of the lump sum they were given on retirement. The number of people who commuted is probably 99.9%, because after 20 years of service plus, many had a need to basically finance their transition into civilian life.
Yeah.
Does that explain that, Senator?
Yeah, yeah, it does. So,
And can I add, Senator Lambie? Clinton Mackenzie
yeah,
here.
please do.
The Commonwealth Ombudsman has found that we were misled as to the effects of commutation as a consequence of poor information, unclear information, ambiguous information. So the Commonwealth accepts that we were given incomplete and misleading information as to commutation. So there's no controversy about that. But that's not the only example of information about which we were told nothing or given misleading information, ambiguous information or late information, and that information relates to indexation, for example, and I can work through that. What we're essentially arguing is that, of course, the Parliament, it was open to the Parliament to legislate in whichever way it wanted the scheme, but the Minister stood up in Parliament and said that the scheme gave effect to the GES Committee recommendations or improved on them, and then the Parliament proceeded to pass an act that did not do that. That statement was untrue. And subsequent amendments to the legislation resulted in a further erosion in the promised benefits, which we only found out about after we'd made very important career decisions to remain in the Defence Force. And for example, myself, I didn't find out about the notional rate mechanism, which I can talk to, until 2021. I didn't even know it was in the legislation, and I can talk to that. And when you track through the information pamphlets on just that one issue, and there are others, there's either information that's not there about that mechanism 4 years after it was put in the legislation, and then each description of it differs, and some of them are wrong. And this is back then, back in the day when I joined, there was no internet. We couldn't get access to legislation. I didn't know what that was. Everything ran on the rumour ripple. And then when these pamphlets came out, they were either incomplete or misleading.
Okay, and just going to the notional rate. Are you there?
Yes. So when the DFRDB Act was made, it diverged substantially, at least in two respects, from those fundamental GES Committee recommendations. First, it said proportionate reduction in the rate of commuted retirement pay, not permanent. Secondly, it recommended, because the committee said, and I'm just reading from the report, it is essential that retired pay should be adjusted automatically with increases in average weekly earnings. And the committee did an analysis versus CPI and AWA and said CPI will result in the benefit being eroded quickly, the value of the benefit. Now, the original DFRDB Act had no indexation provisions in it at all, no adjustment provisions. That was never revealed to us. And there were a couple of one-off legislative changes, and then in 1976, I've got the Cabinet minute here, they resolved to amend the DFRDB Act, put automatic adjustments in there, adjustment provisions, linked to CPI, and at the same time only applying it not to 100% of the benefit, but to a notional rate. So,
what's the... Oh, okay. Okay, now, go back to the notional rate. Yes, please.
And I'll get to the point where I say, well, 4 years after, that notional rate wasn't even explained in the pamphlets that went around, but it was unashamedly this Cabinet minute from 1976. The then government asked for savings measures. They wanted to do things that would save the government money, and it was in the context of the GES Committee report, and that they knew that CPI would save the money compared to average weekly earnings. the notional rate nasty, as I call it, because it is, as I explained, is one of the most deleterious effects in the Act, was based on a fiction, based on a false equivalence with the public sector scheme. DFRDB is unique. All of our contributions disappeared into the Consolidated Revenue Fund, the government's piggy bank, to spend on what it did the week later, the year later, or whatever. 100% of our benefit comes out of the Consolidated Revenue Fund. And with respect to Mr Stone, the previous speaker, that's why APRA is not involved in any of this. There is no fund that CSC is managing for our benefit and investing prudentially for us. Each fortnight, there's a standing appropriation under the Act that takes money out of the Consolidated Revenue Fund and gives it to us. But what the government said, and it's all in there, said, well, under the public sector scheme, only the bit that comes out of the Consolidated Revenue Fund is indexed, so we'll pretend that DFRDB recipients benefit, only part of it comes out of the Consolidated Revenue Fund, even though in fact and in law 100% comes out of the Consolidated Revenue Fund. And so they didn't index part of that. It's about 2/7, is it? Yeah, about 2/7 of it.
It varies depending on the age.
Yeah, and so over 4 years later, the next pamphlet, the next pamphlet that came out describing the DFRDB said nothing about that notional rate issue. Now, what is the significance of it? What it actually means is that if someone didn't commute, then their retirement pay would not be fully indexed. They'd only apply CPI to the amount that would have been left over had the member commuted 4 times. So the easy example, let's assume I'm entitled to $10,000 per annum in retirement pay. I'm going to take the lot. The only thing that gets applied indexation to is $8,500. because that's all I would have had left over if I'd commuted 4 years, even though I'm actually getting $10,000. And that was based on this false equivalence with the public sector scheme. But in that scheme, there was a fund that was invested for the benefit of the members. Our contributions were never invested for our benefit. So we didn't. They picked the bad bit out of the equivalence and not the good bit. They didn't say, "Oh, we will notionally invest your contributions and give that back to you." And that is why when Mr Manthorpe came to the conclusion that we'd been misled about the effects of commutation, he went on to say, but, and this is where the notional rate nasty comes in, because you might say, well, everybody commuted, so who cares about notional rate? He said, but our financial modelling shows that even though you were misled, you were better off commuting rather than not. So you haven't suffered any detriment, right? Now that's a false dichotomy, and Mr Ellerbock can expand on that. But that's why they were able to say, based upon our modelling, you haven't suffered any detriment, because they're comparing it with the uncommuted benefit, only the notional rate of which would have been indexed, and again against CPI. So the comparator was always going to be worse, and so they say you didn't suffer any detriment. Now we say we should have been told about that much earlier. And as I say, in the first pamphlet in 1981, I can give you these, no mention of notional rate. The first mention is an innocuous sentence went in 1980. The next pamphlet is in 1985, right? So that is over 8 years after the Act was amended to put this in there. Now, in the interim, people like me and thousands like me made our second most important career decision of our lives, and that was to commit to further service or not. And that decision was made in the context of what I knew at the time. This was never... So that I didn't know that happened after I had made the decision to sign on. Then in 1987, then they got confused. The next pamphlet said pension increases are applied only to government finance components of pensions. And we say, would that were true, because 100% of DFRDB pensions and benefits come out of the Consolidated Revenue Fund. And any troop reading that would look at that. What do I do about that? What does it mean? And if it were true, then we'd get 100%. That doesn't describe the notional rate. It describes something that didn't happen. And then finally, they got round to, in 1989, the first clear explanation 14 years after that change was made. And we know why this happened, because if after that cabinet decision they'd come out and said the plain truth, guess what, everybody? Despite Jess, we're going to give you CPI linked rather than average weekly earnings relativity, and we know that that's going to result in your benefit being eroded very quickly. Those are the words of the Jess Committee. And what's more, we're only going to apply it to this much. There would have been mutiny in the Defence Forces. The troops would have gone, what the? And I'll leave it there. And Mr. Ellerbach might want to explain why that trick that the Ombudsman pulled is a false dichotomy.
Senator, I can give you an example, a lived example of mine in my particular case. 1978. Now, this is the year after the indexation provisions were implemented. At that point, the DFRDB authority published no information, no information about indexation. Now, I was faced with a very clear career decision at the time. I had already reached the top non-commissioned rank. I was one of the youngest to achieve that rank. But I had to make a career decision. Do I serve through to the minimum requirement for the DFRDB, that is 20 years, so that I was entitled to the retirement pay and a commutation? Or do I seek a commission and serve on for as long as I could? I have a strong background in applied mathematics, and I was able to do the numbers. And it was clear on the basis of comparing, say, 3 different age groups of me retiring after 20 years or after 30 years or after 40 years, the clear comparator said my best option was to retire after 20 years. And, the numbers are unequivocal. Had I known about the indexation provisions and had I been able to apply the partial indexation to my retirement pay entitlement, the outcome would have been completely different. And as it turned out, the outcome was that retiring at the earliest age was the absolute poorest choice for me. The best choice for me would have been to serve for as long as possible. Now, we're not privy to the demographics or the membership that is still surviving, but I do have a database of at least 630 members, and on the basis of those experiences, more than 50% served only 20 years, 20 to 21 years, and took their commutation. So of all those, 50% of the members have all taken the poorest choice and made the poorest choice on the basis of the information provided. Now, the government's got, the Finance Department runs a scheme called the Compensation for Detriment Due to Defective Administration. Now, the Commonwealth Ombudsman in 2019 devised a tailored version of that members who felt that they were financially disadvantaged by being misled about the DFRDB scheme could submit claims against that scheme. Now, I understand
How's that going? How's that going? Anyone had a win?
I understand that some 40-odd claims were submitted and all of them were rejected. Now, some years later, I submitted a claim which had nothing to do with commutation, and that was the tailored version that the Ombudsman created in 2019. I submitted a claim in 2023 on the basis that the information that I was supplied led me to a totally inappropriate career decision which worked to my substantial financial detriment. Now, that claim was almost immediately rejected by defence. I objected to that, which they accepted as a request for a review. Some 300 days later, I received a revised decision by the original decision maker who reviewed her own decision and, lo and behold, upheld her own decision. Now, I was not satisfied with that because I didn't feel that I received any procedural
I'm sorry,
justice.
so we just go over that. So the person that actually made your claim is now reviewing herself,
Correct.
doing her own homework
Correct.
and saying nothing wrong here. Oh,
Correct.
God, this keeps getting
Nothing.
better this morning.
Well,
Righto.
it gets better, Senator. It gets better. So I've referred that decision to the Commonwealth Ombudsman for review. And some 450 days after, it's now been 800 and something days since I first submitted that application. 450 days after I referred it to the Ombudsman for review, he came back and he said, no, we're not going to review your decision. Go away. Now, I'm now wondering, where do I get some justice out of this?
I don't know, but can you supply me always, please? Because I'm going after that. I want to know why. And 450 days to tell you that's rubbish. So I want to see what was going on in the back of that and who was speaking to the Ombudsman at the time.
May I say that I only got that response after submitting a what do they call it, a complaint against the Ombudsman's lack of service.
Who was the decision maker?
The decision maker was from the legal department of Defence Legal. Now, the first person who tried to deny my CDDA reference to the Ombudsman turned out to be an Assistant Secretary of Defence, but he called himself as an Assistant Director of the Ombudsman's office. Now, there is some problem here with conflict of interest, let's say, for a better word. But let me also be clear, my CDDA application is, as I understand it, is still the only active one. And it has not yet been resolved to my satisfaction, and I don't know where to go. I suspect I need to go to the Minister for Finance, who runs that scheme, and perhaps the Attorney General, who might be able to make some decisions about my legal rights. The Senate committee that, Senator, you'll remember it in 2021. You were on that committee. There were two recommendations from that hearing, and the second one of those recommendations was that anybody who submitted a claim under this CDDA scheme should be entitled to some sort of legal assistance and perhaps help of some sort. The government, as I understand it, has not responded to that particular recommendation. I believe I'm in that position now where I should be entitled to some sort of assistance to take this matter to somewhere, and I don't know where that should be, to get some justice over the matter.
Okay. Okay. All right. Well, I want to speak to you guys afterwards and continue this matter through now and finally get to the end of this matter about this. This has been going on ever since I've been up here for 10 years. So something needs to come out of this committee because I'm certainly not going to get another one, and something needs to be driven. So I have no problem with doing that. Can you, when you first signed up, when you switched over from the old, what was it, to the DFRDB? What was that first one? The DB or something, was it?
DFRB.
Can I explain?
DFRDB.
Can I explain that, Senator? So initially, at least 3 of us here were serving under the old scheme. Our contributions were 5% of pre-tax salary. Yeah. And what happened when the new scheme came along, and that particular scheme was a funded scheme, so our contributions were paid into a fund and invested. Depending on what people's longevity was in the service, the rates of contribution started to ramp up the longer they served, and some of the contributions were far in excess of 5%. Now, Jess recommended that the DFRDB scheme should be an unfunded scheme. So, and recommended that particular DFRB fund should be wound up and paid back into consolidated revenue. But the mechanism was that they calculated what everybody's contributions were into that particular scheme, and then calculated what their contribution should be under the DB scheme, where the contribution rate was 5.5%, over that same period of time. Now, if the contributions under the DFRB scheme exceeded what they would have been under the DFRDB scheme, the difference was refunded. In most cases, given the contribution rate of the first scheme was 5% and the second was 5.5%, the bulk of us were given the opportunity to pay the difference on retirement. So in my case, I had to make up whatever the difference was. It wasn't a substantial amount, but that's basically how the mechanism worked.
Oh, that's where it comes from that original scheme. Right, that's the connection that I lost. Okay, and this is how come you've now paid that bloody extra 0.5% over and over and over and over and over again.
Correct.
So why don't you explain that to the committee? Oh, I see. Right.
And it's where the folklore comes about somebody stole our money. Was it Whitlam stole our money? Now, all of that fund went into the Consolidated Revenue Fund, so it did disappear, but in return, people had entitlements under the DFRDB scheme, the new scheme. So it wasn't as if they lost everything. And in fact, under the DFRDB scheme, let's say someone had been forced compulsorily to go over and their money was stolen by the government. If they then died the next day, they were entitled to a refund of those deemed contributions. So it's a very complicated scheme, and that's why there's all this folklore out there about Whitlam stole my money and these commutation factors of 20 and all that sort of stuff. But it's exactly as Mr. Ellerbach explained.
Senator,
so let me get this right. So you were contributing, plus Defence was meeting you, or whatever was meeting you. Was that happening back then? So if you were putting 5% of your wage in, well, they top it. What was the go? Is it like the MSBS?
Yes.
Yes.
Okay, so it was. So if you were putting in 5%, they were matching you at 5, or whatever. If you were putting in 2% or 3%, they were matching you at 2.5.
The ratio was actually greater than that. It was more like about 2/7, like many of the other schemes, Commonwealth schemes. About 2/7 accounted for contributions. The remainder came out of consolidated revenue.
Okay, so when you left, you were able to take your contribution that you made?
No.
Right.
They bore no relationship to each other because it was a defined benefit scheme.
Okay, I got you.
And if I may, Senator, the DFRDB was unique because it had to be unique. For among other reasons, is the DFRB scheme wasn't working, and in the wake of the Vietnam War and the end of conscription, there would have been no credible defence force in Australia but for things like the DFRDB scheme, where you could go in and our contributions bore no semblance to our entitlement at the end. We only had to remember 2 numbers. So when I joined at 15, I had to remember 2 numbers, 20 and 35. if I serve for 20 years, I will be entitled to 35% of whatever salary I get in that final year. Doesn't matter whether I'm a corporal, doesn't matter whether I'm a warrant officer, doesn't matter how much money went in. Those are the two numbers that I needed to remember and get on with being a member of the Defence Force and not getting caught doing anything bad and getting promoted. Instead of spending days wondering how much is in my fund, how much is the fund making, get into the PSS calculator. It was a very simple scheme and it had to be, and people point it and say it was generous. Well, it had to work the way it did, otherwise Australia wouldn't have had any credible defence force in the wake of Vietnam.
Well, I have to say I'm not sure it was very generous, because the lower you come down those ranks, the less they get in retirement.
Well,
and you would have had plenty of 20-year full corporals running around.
Exactly, Senator. And look at the previous speaker. Lots of DFRDB members have to rely on the age pension. So if they're relying on the age pension, and as I said in my submission, I served in a trade which is the highest pay scale in radio technicians, two below. My DFRDB pension when I got out was below the recognised poverty line. It's in my submission. The numbers are there. Now, as I said, I didn't expect to be able to live in the lap of luxury, but nobody ever said when I served and signing on that could be the outcome. But that's how the maths turned out. What people focus on with generosity is the capacity to get access to the benefit younger than retiring age. That's it, and it's mainly public servants who just don't like that and they see it as being generous. But again, people committing, I say to myself, think about 20 years of the best years of your life, 15 to 35. If they'd said to me, you're going to have to contribute, we're going to take money out of your pay, it's going to disappear into the Commonwealth's piggy bank, and you're not going to be able to get access until you're 60, I would have said, I think I'll go somewhere else, thank you very much. Because at the age of 15, 35 is an old man, and 60 is a dinosaur. It's just that those sorts of features would have resulted in the DFRDB not achieving what the government desperately needed to do. And back then, in the mid-70s, the Defence Force, permanent Defence Force, was around 75,000 people. Today, the government barely scrapes together 63,000, and in the interim, the population of Australia has doubled. So the DFRDB worked. But then we find out decades later all of these little things that weren't explained to us in plain English, in troop language, in 1978, and et cetera, et cetera.
So
Senator.
The idea behind... so the idea that if you join the Defence Force, because it was in part a recruitment push, right?
Yes.
That you join, if you join at 15 and you do 20 years and you leave at 35, then you're paid your pension from 35 onwards.
Yep.
So the concept...
Yes.
Cool.
It's a conceptually brilliant scheme.
But the communication, the information and such, like a bit like your decision, Mr Ellerbach, that, had you stayed in, had you made a different decision from 20 to 30, what would that difference have made? Is there a percentage point at 30?
Oh, absolutely.
So you're saying 35 for 20?
First of all, serving up to 40 years gives you 76.5% of your final salary.
Right.
So that's a graduated scale, commencing it actually commences for some of the naval recruits as early as 15 years. But for the majority, it was from 20 years onwards. So it's 35% at that point, ramping up to 76.5%, and probably only a few generals probably qualified for that length of service. Obviously, the reduction of those benefits had a lot to do with the age on retirement. So the younger you were, the smaller the reduction, the older you were, the greater the reduction. But the effects differed substantially. You know, if I went back to my calculations where when I looked at that initial arrangement before it was indexed, and it said, you know what, my best position is after 20 years I should leave. But when I applied indexation to it, the picture was entirely opposite. It was a completely opposite picture. And if I just compared the retirement benefits alone, the difference is probably up in the millions.
So if you left the Defence Force at 35 and you were fit and able to enter the workforce, then, you know, that's kind of good. You've got this extra money coming in. But if your service has meant that, you know, your capacity to enter into a different career is adjusted because of your experiences.
Yes, thank you for that question, because for most of us here, our service qualifications and experience translated into civilian employment. But for many, it did not. It did not. And that is why many had to retire, you know, before the age of 40. Their military skills didn't translate into civilian employment. And perhaps some of them were damaged. They didn't all get a TPI concession. Many just went bush, and they have to survive on their DFRDB entitlement and the age pension.
And Senator, that was one of the reasons for the commutation provision, was to help people leaving defence move into civilian life, either through get themselves re-educated so they could actually transfer their skills, or to build a house, because in those years in defence, people were posted routinely every 18 months, 2 years. So buying a house or settling down somewhere was just impossible. So that's what the commutation was all about, was to try and give us a lump sum that we paid for, where they recovered that money from us, just to help us get over that transition period.
And set yourself up for a civilian life.
Correct.
Yeah.
Correct.
Senator, if I could add to that, even for those of us who understood that commutation actually wasn't a really good deal, even without indexation, you know, when you looked at the numbers and you said, okay, you know, if I live beyond the age of 72, it's going to start to cost me money. We knew that, but we needed that money. We needed that money to transition into civilian life. I had 20 years of moving around. Half of that was as a married man, carting my family all over the country and out of the country. I didn't have a house, so those funds were needed to set us up.
Okay, thank you. Thank you very much.
I should just say again, briefly, in my case, I left as a wing commander after 25 years service, and just recently I'm now eligible for a part pension because the DFRDB is inadequate or doesn't bring me up to the pensionable standard. So, you know, my DFRDB is $44,000 a year, and now I'm drawing about $550 a fortnight on the pension. It's a part pension. So
For an ex-airline pilot, Senator.
But,
if I may, Senator.
but on top of that,
Sorry.
also in my 25 years, I lived in 5 different countries in 25 different houses, just to give you a measure of the inability to actually settle and buy a property or set yourself up with a house. So that's probably a bit extreme, but that was my case. So
Thank you.
If I can add, Senator Grogan, and it may seem a trivial point, but what we're entitled to is a thing called retirement pay. And the GES committee chose that term, retirement pay, rather than pension, because members of the Defence Force didn't want to be perceived as needing welfare to survive after decades' service in the Defence Force. So I keep telling you that the bureaucracy loves pension, because when they call us pensioners, it's then much easier for them to wrap us all up with the welfare population generally and say, well, they get CPI over there, so why should you be better off? But the fact is, our generous benefits, as Ron said, have to be supplemented by the old age pension. Not in my case. My boyish good looks may not be visible in the camera, not there yet, but even for senior officers, relatively senior officers, it has to be supplemented by the age pension.
Thank you. Thank you very much.
I just have one final question, unless somebody else has one. Does anyone done the rates of what, had you been on the Matawi or the male equal earning wage or whatever it's called these days, you know what I'm talking about, instead of the CPI, have one of you worked that out on what you've actually lost at all, just one of you, or if anyone wants to answer that?
On average, 30%.
And that
substantial.
That was the initial promise that you were supposed to be on that rate?
Correct.
That rate? The male equal earnings or whatever they call it, something else.
And there was an adjustment, a Fair Indexation Act enacted in 2014, which applied a very similar indexation mechanism to DFRDB that exists for the age pension. And I think the only difference between the two is that the age pension is compared against a baseline of 25% of average weekly earnings. In our case, in our case, that percentage is 27.7%. Now, the indexation formula basically says now that DFRDB will be adjusted twice a year against the best of the CPI or the Pensioner Benefit Living Cost Index, whichever is the greater. And then whichever of those two is the greater is then compared to 27.7% of male average totally weekly earnings. Now, since 2014, male total average weekly earnings has never affected the indexation of DFRDB benefits, or the age pension, mind you, because that percentage is so low that it'll never have an effect unless you had massive wage rises for multiple years on end.
And can I say, add to that, there was no adjustment to make up for all of the erosion between 1976 and 2014. It just, those new provisions applied prospectively. And I just wanted to touch on the nuance of this thing about what we were promised, because the folks who are against us will pick up on that. It wasn't an express promise, it was implied. It was implied that we would be told how this scheme actually ran when they made the amendments to it. We were entitled to that. And if these things happened in 2026, the DFRDB scheme would be the subject of a centimetre thick product disclosure statement. Everybody would have access to amendments and all that sort of stuff. We should have been told in plain English when those amendments were made what their real implications were. And as I said before, the reason they didn't is because they knew the outcome was going to be. And the Jess Committee report said, here it is, that retired pay be expressed as a percentage of final pay and be adjusted annually so that relativity with average weekly earnings is maintained. And the Minister said that and all the other recommendations were given effect to in the DFRDB Act. Now, I believe, just as an aside, I think the Minister was misled. It was the heady days of the two-person cabinet and they were just legislating like there was no tomorrow, and no minister would have had the time to actually get his or her head around what the DFRDB Act said.
Chair, can I just ask one final question related to that? I mean, there's so many issues that obviously you feel misled or inadequate about the scheme. I'm just trying to quantitatively understand which of in the hierarchy of things, whether there was the issue about how they were indexed, whether it was linked to CPI or average weekly earnings or another factor, and what proportion of it was linked to it. The issue about whether the commutation was to be temporary or permanent, the life expectancy factor, the commutation multiple factor. There's a range of issues you've all raised. And which ones in the hierarchy are actually quantitatively have the biggest impact?
By far, it's indexation. The permanent reduction in the rate of commuted retirement pay when you do the numbers, and Herb's the analysis, and he'll correct me if I'm wrong, it's a second order issue. And that's why we at ADFRA, who we're experts in the DFRDB, get frustrated at the focus on commutation, because it's a distraction from the main game. And our enemies are happy for that to continue to occur, because all they say is, well, you were better off commuting rather than not, so even though you're misled, too bad, too sad. And we keep trying to explain to them, you better... The reason that happens is that most of them don't understand even the notional rate thing. As I said, I didn't get my head around it until 2021. So those amendments back in 1970, they came in effect in 1976, were what set the path for the subsequent decades.
Thank you. That's helpful to understand that.
Thanks, Senator Dowling. If no senators have further questions, I will thank now the Australian Defence Force Retirees Association. Thank you for your service to our country, all of you, but thank you also for appearing today and your submission as well.
Could I have a 90-second grab in conclusion?
Yes, final 90 seconds.
You're not going to give me 90?
Yeah, you can have 90 seconds.
Thank you. Later today you'll hear about a document called the DFRDB Authority Circular 1973 Issue 7. It clearly stated that if you took commutation, you would pay the penalty for life. That document was issued to Formation Headquarters, and our research, and I'm sure we've convinced you today, has been very thorough. We can never find that document got out to unit level. So we've got this great document. It told the truth, or what they said was the truth. There is no indication of the level of distribution. So shortly after they issued that, the DFRDB authority put out the first of the brochures that Mr Mackenzie has shown, and it didn't even mention it. And it didn't mention it until the year 2004.
30 years later.
Yeah, some 30 years later. Yeah. Now, is this a minor administrative oversight, or were we being misled?
Thank you, Mr Hinslow.
The other thing is that the Ombudsman and the FATT Committee accepted evidence from the Department of Defence where they claimed that the commutation part of the DFRB Act and the DFRDB Act were mirror images. That is totally wrong. That never happened. And I could table that paper if you wanted to see it. They are not the same.
Please do table that, Mr Hinslow.
Table, thank you.
Committee members, I'm conscious we're slightly over time. We're going to suspend for a short break now. I'm going to suggest we return at 11:10 to give people time to actually get a coffee. So we'll be back in 15 minutes. Thank you. Welcome, a representative of Advocates Online. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today, and then I will invite you to make a short opening statement.
Kelly Marie Jackson, CEO, Advocates Online.
Thank you, Ms Jackson. Have you got an opening statement you'd like to make?
I do, thank you, Chair. I'll try and keep it short.
Go ahead.
Good morning, Chair, Senators, committee members. My name is Kelly Jackson. I'm appearing as the Chief Executive Officer of Advocates Online, professional advocates and custodians, dedicated to the personal, social and economic dignity of veterans and their families. I am a 22-year military veteran. As the Vice Chair of the Veteran Professional Standards Australia Advisory Committee, I'm acutely aware of the complexity and challenges veterans and their families experience from the beginning of their careers. It's not welfare veterans want, it's knowledge and the right to make good decisions for themselves. Today, I represent them. I do not present to the committee with opinion. I come with lived experience, a learned mind and evidence. This inquiry is important to veterans, their families and the Australian government. The commitment to ensuring the personal, social and economic dignity of veterans and their families is every Australian's responsibility. As Australian citizens, we have all made a commitment to the Veterans Covenant. It acknowledges the unique nature of military service and sacrifice. We are obligated, in fact, we are duty-bound, to ensure those who make the commitment to serve in the ADF are looked after during and after service, and we must ensure they suffer no disadvantage as a result of their service to the nation. Veterans are exposed to a far greater probability of permanent and degenerative injury, illness and disadvantage from the time they sign the dotted line. This is confirmed by the Defence Act, Veterans Entitlement Act, Military Compensation and Rehabilitation Act, Australian Veterans Recognition Act, and the role performed by the Defence Force Remuneration Tribunal, an independent statutory body established under the Defence Act. The various acts confirm veterans are a special class of citizen, not because of intellect, because of their exposure to sometimes severe occupational hazards. The evidence confirms the probability of injury and illness. I refer to the DVA Lighthouse Project, the DART, the Senate Inquiry into Veteran Suicide, Royal Commission, and we take time to remember on at least 2 occasions each year, being Anzac Day and Remembrance Day. These are not days confined to commemorating World War I, World War II or Vietnam. They're days to remember the 41 lost during the almost 20 years Australia committed troops to Afghanistan, the on average 70 who take their lives each year, and those who succumb to their injuries, such as my dear friend Em's husband, who passed leading his soldiers during a PT session, leaving her with 4 children, and an enduring sense of loss, grief and abandonment by a system who could have done better. The evidence confirms veterans will do better with economic dignity, and that comes legitimately through superannuation. There are 2 matters of importance today, although I've made 27 recommendations. The veteran journey and the conduct of the trustees in determining invalidity entitlements. And I want to acknowledge and respect the previous speaker's representation. So very important. And I'll give you the figures because they asked me to. The difference in a commutation and a lifetime pension and a medical separation. They're better off medically separating. 40 years, pay back your 40 years of her pension, pay back your commutation and still have over $1 million in your pocket. That's the difference for them. Significant. In 1993, under a Labor government, and I'm not political, insurance for disablement was introduced through the Superannuation Industry Supervision Act 1993, creating additional safeguards under the superannuation guarantee for people who were occupationally impaired. Civilians can have one super for life if they choose, but a veteran must find a new superannuation fund and buy new total permanent disability or invalidity insurance when they leave, when they stop serving. If they do what the DVA, the ADF and their mates tell them and get all of their DVA claims submitted prior to discharge, they are likely to be denied TPD insurance. Noting only 6% of veterans fail to go on to other employment. Without TPD cover, they will be working with no insurance. Even more concerning are the exclusion clauses around military service in other superannuation schemes. Just last week, I had a veteran contact me after a post-defence career of more than 10 years who succumbed to injuries, and his insurer is refusing to pay out his TPD because he served in the military and for no other reason. The issue is not so much with the legislation, except for DFRDB, I will put that caveat there. It is for the veteran to know the appropriate time to take action, the length of time decisions are taking to be made, the quality of those decisions, and the failure to harmonise between the government departments and the legislation, leaving gaping holes. Chair, Senators, may I please confirm what we all know our greatest challenge is: human beings. We are flawed and experience chaos as the natural state of existence. To create psychological order, we rely on the law, policy, process, and a coherent framework made up of individuals who are trained, resourced and supported. This is what I believe the Commonwealth Superannuation Corporation is missing. Here are the consequences of poor interpretation of policy and the imperfection of a system reliant on individuals without the right understanding, training, advice, resources and leadership. John joined in September 1988 as an infantry private. He served through to 2000, achieving the rank of corporal, the lifeblood of the Defence Force. On 19th of June 2008, at the age of 57, John was re-enlisted to the Army, not because they were desperate for a body, but because of the directed recruiting and requirement. And he was going to be from an infantier to a dental assistant to meet the directed training requirement. At 57, with already 20 years of experience, in the wisdom of the Defence Force, they sent him back to Kapuka. In full transparency, upon re-enlistment, he had buggered knees. What do you think happened? Within 3 weeks, he was medically separated because he could barely walk. When he applied for an invalidity pension, he was denied because some bright spark medical doctor failed to write he was materially aggravated by his service. That man, who I have the pleasure of seeing often because he lives in my hometown, has given up his business, couldn't go back to work, and now lives in a shipping container in a storage yard, destitute. Now there's Hank, and I've changed the names, a 17-year Special Forces veteran with 11 deployments, multiple physical and mental health injuries, and yet the enduring spirit of the Anzac burns hot in his veins. Despite the complexity and multimorbidity of his conditions, he's a proud man, a husband and a father who has a family to support. Unable to perform his defence role, he studied and secured a job post-service, relying on his residual functional capacity. He continued to contribute to the economic well-being of his family and not drown in the reality of his situation in just his late 30s. His application for retrospective invalidity denied, not based on the medical evidence readily available to the Commonwealth Superannuation Trustees, but because Joint Health Command decided, by way of a desktop review and a bland medical file, nothing was wrong with him. Despite having 69 Mercer impairment points and a gold card, which was sent to the Australian Defence Force to put on the member's medical file, but didn't. 4 years later, We are still trying to wade through the ADF and CSC processes, none of which quote a wait time of under a year. A family left abandoned and in distress. I have one final example. The RAF Airfield Defence Guard recently told the only way he could get upgraded to a Class A pension was if he ceased to work at all. A complete misinterpretation of the legislation. We all know that when a person leaves work, their well-being decreases and the rate of suicide increases. 60% pension, Class A pension is 60%. That enables you to work 3.2 hours a day, 5 days a week. That sounds nothing like unemployment to me. I believe it's important to be intentional and clear. So I'll conclude with this. I'm not here to personally criticise or diminish the hard work of the staff within the CSC, but I truly believe they have been failed by their legal team in the interpretation of the law, leading to inadequate training, policy, process and procedures, and in my world, that comes down to a failure of leadership. For 6 years, I have been making submissions to the CSC, and for 6 years, I have been raising the same issues about the failure of the delegates to make decisions that would survive judicial review. I've beseeched them to fix their forms from the ADF through to the CSC. I've implored them to become more sophisticated in their understanding and inclusive of the mechanisms and frameworks available to them to make distinguished decisions. And yet two things strike me as disturbing. The excuses and inability to make cogent arguments or present any at all that suggest the submissions made on individual cases and collectively are wrong. They have been invited to prove us wrong and yet have not been able to convince us to this date. A word said does not make it true. A decision signed does not make it sound. And the ADF and CSC leadership have the power. They must take this responsibility very serious. Senators, I refer you specifically to recommendations, because it's too long, to recommendations 13, 19, 20, 23 and 25. That ends my opening statement.
Thank you, Ms Jackson. I'll ask Senator Lambie to start with the questions, and just if everyone could be mindful, we want to move to the next witness in about 20 minutes.
Okay, no worries. Thank you very much, Ms Jackson. I know you've been playing in this area for quite some time. Thank you for your longevity of service. All right, okay. Once upon a time, we used to rely on composite because they were a hell of a lot faster than DVA, and we had to rely on us to get that money. How's it gone? How does it go in 10 years or over 15 years, go from 6 to 8 weeks or 6 to 10 weeks maybe, I'll give them a little bit of that, to now waiting nearly 18 months to get a decision from ComSuper? What is the problem? And why, Mr. You may want to explain to these people what A, B and C is. Can you explain all that plus that answer for me, please?
Yes, Senator. So I will firstly address the Class A, Class B, Class C. A person can be medically separated, and I'll use one legislation, under MSBS Rule 30, for not being able to continue serving in the military on medical grounds. That does not translate into a pension. They must then be assessed under Rule 22 for a reasonable employment kind by way of vocation, trade, professional skills, qualification and experience. A Class C is no invalidity pension, which means if their conditions that they've agreed medically retired them decompensate, they cannot ask for reclassification. A Class B is 30 to 59% level of invalidity or restrictions for employment. A Class A is 60%, 3.2 days by 5 days a week. To answer your question on why I personally feel that the timeframes have changed, Senator Lambie, I would suggest a couple of things happened. There was introduction in about 2022 of new systems where I saw a distinct change in timeframes, and I also don't think that the CSC staff or the FTE is properly resourced in order to get those decisions made. I know those staff are under extreme pressure and distress to make those decisions. So I would put it down to a staffing issue, hence why I've laid the blame on the leadership of the CSC.
Okay, thank you for that. But is that becoming a problem with when you're dealing with veterans? Because we do rely on that money, some sort of money or small payment coming through to keep us going. Why? I mean, that was the biggest gift of that, many years ago, was to have that done quickly. Well, too bad if you got a C on one of those Cs, so we'll come back to them at a later date. But those A and Bs, they get out, they're not living on anything, they're fighting a system. And we can no longer rely on using, going into our own super and getting super payments either.
18 months, Senator, 18 months. And if they get denied, and I only have 14 days generally, maybe 21, to submit additional evidence, I can't get a doctor's appointment in under 6 weeks or an occupational capacity assessment in under 6 weeks. If they're denied, it's a year, at least a year for recon. Keeping in mind, my staff have to go back over the evidence, so that takes us a good 6 weeks alone just to go over the evidence and pull it apart. A year.
Okay. Do you want to maybe explain? Oh no, actually, that doesn't matter. No. Is it? Does the other committee? There members of the committee that have questions? Chair.
Senator Lambie, I'm happy to defer to you on this. I might have a few, but
oh yeah, okay. I might just let you go because I have seen Kelly recently, so it might be more beneficial for you guys. I mean, I've got questions, but if someone else wants to jump.
Well, let's just go around the room. I'll see who else might have questions. Senator Grogan.
Yeah, thank you. Thank you, Ms Jackson. Thank you for coming along. What are the kind of recurring themes that you're seeing? Is there specific stuff that you're seeing come through in terms of issues that are not getting processed, or is it just across the board?
Look, the time frame is the time frame. Thankfully, veterans have been putting up with that with DVA for quite some time, so they're actually very patient. The issue that we have with the submissions are around this obsession with contemporaneous evidence. The legislation doesn't require it. It says any evidence, and yet the delegates keep asking us for contemporaneous evidence. They are ignoring medical evidence. They've a couple of times gone to MLCOA and asked a GP to override a psychiatrist report. They're not medical trained people.
Sorry, Ms Jackson, you might want to tell them about MLCOA while you're at it so they fit that into the equation and what's going on. Thank you.
MLCOA, independent medical assessors. A desktop review is done by a general practitioner, and there's already, because of the DVA increasing the load on MLCOA, there's already a 4 to 6 month wait. I've seen 3 reports from MLCOA. I could almost overlay them from each other and they're the same, and they have contradicted Dr. John Lane, the senior psychiatrist of the DVA. It makes absolutely no sense how they're coming up with denying medical evidence and obsessing around contemporaneous, because it doesn't exist. And I have an email from the Commonwealth Super, which I've included in my submission, where I asked, does it exist? And it doesn't.
So why do you think that the medical advice is not being taken up? What are you given as the rationale for medical advice being ignored in these assessments?
I think, as I said in my opening statement, I do not think the team are being properly supported by the legal team in the CSC, and I don't think that they're being given adequate training on how to make an assessment. Our submissions, and I would be happy to supply one redacted, our submissions are very, very tight, and we provide the evidence to lead the delegate to making a positive submission, because we don't take a case if we don't think they can win, because that's horrible for everyone. The second part of back to the question previously, the second part is the employment kinds. There is no decision matrix on establishing an employment kind. They rely on the Occupational Standards Classifications Australia, and there is much better evidence to establish employment kind. The TAFE system, the DFRT, so the Defence Force Remuneration Tribunal, which looks at civilian salaries and equates them to military. There is so much better evidence to use than the OSCR, and they're just guessing. So I've got a Special Forces soldier security of 17 years service or an infantier. Oh, you can go be a security guard. That's a one-day course. A one-day course to be a security guard, and yet this highly trained 4, 6, 10-year military veteran is being told they can be a security guard. Not only is that humiliating and insulting, it's just legally judicially unsupportable to make that assessment. A bosun's mate who's a mastery gunner does boardings in rough seas onto very dangerous, potentially dangerous vessels with drugs or refugees or terrorists. They're being called deckhands.
Okay. So in terms of the translation for ADF personnel into civilian roles, now my understanding, and I'm no expert in this field, is that things have changed over time in terms of qualifications, and the ADF actually trying to have qualifications that then translate. Mm-hmm. So where you're actually obtaining skills, that those skills are now they're working through getting so they're certified, so that when you leave the military you can actually use that, which didn't used to be the case. Is that right? Are you seeing any evidence of that making things any better?
No, Senator. We provide a layperson's understanding of what's called the Record of Service Long, which lists the qualifications, skills, licences, competencies. It's all listed there. Some people have got 10 pages of these competencies. In my opinion, they're being completely ignored. Oh, you were an infantry person, you can be a security officer. You were a bosun's mate, you can be a deckhand. So they're not utilising it. And I think it's because they're busy. I mean, I don't want to be unkind to the staff. I really do think that they're very, very busy, and I think there's this new traffic light system to move cases along quickly. And in my world of looking after and representing the veterans, you prosecute the information and the evidence until there's nowhere else to go, and you can make a decision that will survive judicial review. These decisions will not survive.
So once you get a decision that you think is incorrect, what's the appeal process and how far can you go?
So we get a draft decision. Sometimes that's the first time we will know what's going on in the delegate's mind. We then have 14 or 21 days to come back and say whether we agree or disagree or give them more evidence. Once the decision is made, we can appeal. We have to notify reconsiderations of the intention to appeal within 30 days. We do that immediately, and then we've got really as much time as we like to make the submission. But the committee only sits every couple of months, and it's a committee of 6 Defence Force people, 3 current serving and 3 former serving. So at no stage through this process is there a medical person or a legal person on the appeals thing. In fact, in the legislation, there is supposed to be an invalidity committee that make these decisions. But the legislation also allows the CSC to use their discretion and appoint anybody they like as a delegate. They've decided, from what I can gather, that they will appoint one person to make the decision. FOI'd years ago, they used to use an invalidity committee, and a committee would be made up of about 3 people minimum. They're not using that, so there's no medical touch point, there's no legal touch point, there's no consistency between the decisions. We can see decisions wildly different. A good case officer who's been doing it for a while to somebody who's got a different interpretation.
And how do you go on appeal? What are your rates of success like?
So our success on invalidity pensions went from about 96% down to 93% recently, and our success on appeals is probably Probably I'd say 90%, and we just recently won an AFCA case as well, because that's where you need to go to next. So that poor man and that family waited 5 years for us to get it through to AFCA, and it was overturned because he was never able to be a mechanic ever again. And that's what we said in our initial submission. This is not a reasonable employment kind, according...
So if you're getting a over 90% positive rate on your appeals, that's quite high.
It's exceptional.
Okay.
Because we were right.
Yes, indeed.
But people shouldn't have to wait that long, Senator. 18 months in the first instance.
I'll be honest, I'm looking at this from a systemic perspective. I totally agree that the wait times for these kind of processes are really difficult on families and on people as they're working through it. But I think from our perspective on the committee, if we just say we take that as read, we go, what are the systemic issues that we can look at? That's probably where I'm headed. Hence probably the colder end of my questioning, if you will. Okay, and your rates of appeal have they changed over time?
I actually got cranky and told them to pause all of our cases until I could go and do some more work on making sure that our reconsideration submissions were even tighter than what they were. So we're hoping to dive back into the reconsideration case and get those cases through now. So 90% is good, but I don't have any figures in the last 12 months because we held off on our reconsiderations.
Okay, thank you. Thank you very much. I really appreciate it. Thank you, Chair.
Thanks, Senator Grogan. Senator Dowling, did you have...
Yeah, just one quick one following on the same theme as Senator Grogan. You've sort of suggested in some of your submission that the CSC is applying evidentiary thresholds beyond what the legislation actually requires, particularly around psychological injury. So could you just give some example where those claims have been rejected, even though, in your view, they meet the statutory criteria?
So if we, thank you, Senator, if we look at the evidence around the disclosure of mental health injuries, veterans are generally not disclosing. Quite often, a person won't know that they've got a psychological injury, and it won't be known potentially for 2 to 5 years or more after service. That does not mean their condition is not manifest, and manifest means causing them restriction in life or employment. When we go and get a psychiatric assessment and the psychiatrist is willing to refer back to the date of discharge, that is being entirely, in some cases, discounted. And that's where we're being asked for more contemporaneous evidence. Where's the evidence that suggests this person was suffering a psychological injury? And we usually provide that, whether there's been like a slight change in a POPS, psychological post-operational psychological assessment. If we look at the campaign and it's been intense and the person says there's nothing wrong with them, there's only 2 conclusions I can come to with that. They're either a psychopath or they're lying. And most of us tell us that they just don't want to go and disclose that. But that evidence is being ignored, and I'm not really sure how the CSC delegates can introduce this need for contemporaneous evidence when the longitudinal evidence, when you put all of the pieces of the puzzle together, dysfunction in the family, DVA claims and assessments, which are rigorous, independent medical assessments, and family dysfunction, multiple jobs, all of those pieces put together with a psychiatrist report on top saying, oh, yes, they were unwell and I can see the factors of dysfunction, that's being ignored, discounted or downplayed.
Okay. So in many ways you're sort of suggesting rather than the claim system being just really complex, it's actually functionally inaccessible for a lot of people.
Well, yes, because of the person, as I said, the human being making the decision, and that's why I've made a point of saying it's a lack of understanding of the legislation, training, resourcing, and when you're overworked, you make mistakes or you do things quickly. So once again, I don't want to be disrespectful to those CSC staff who turn up every day and dedicate themselves to this, but the leadership need to take some responsibility and do something about it.
Okay. Thank you.
Senator Lambie, have you got another question?
Yeah,
Please go ahead.
just a couple. Those dysfunctions, I'm assuming, Ms Jackson, you're coming across that a lot of those dysfunctions towards the end there are actually caused by ComSuper and DVA because of their timing, and they're at times their paperwork that's going back to the veteran. Are you finding much of that?
Absolutely, Senator. So it's about giving the right advice. So we've done a lot of reacting. Because the DVA timeframes are so long and it's so drawn out and people feel brutalised by it, the ADF to cover their butt, perhaps the DVA to cover their butt, and the MATES system, they're all telling current serving veterans to quickly put their DVA claims in now. Now, we just saw it recently happen. A man with 87 points had a heart attack whilst on deployment, and the information sent from DVA to Defence was lost. They've now miraculously found it. But if a veteran does that after only serving 8 years and they submit all of those DVA claims, remembering only 6% don't go on to other employment, they won't get TPD insurance. They will be excluded because there's too many injuries. They now have no insurance because when they stop serving, they stop contributing to super. There goes their insurance for invalidity. It doesn't endure.
Okay, and I just have one last question for you. The likes of Milcoa, ComSuper, what I've seen happen in the past, and I know still happening, is that the veterans taking their documents or sending their documents in, they're not looking at it because they're only looking at the documents, the missing documents that go missing from Veterans Affairs automatically show up. They're only seeing part of the medical issue because they are only getting paid so much, especially those independent medical practitioners out there are only getting paid so that you go in, you say, this is all my thing, and they go, no, we're going to base it on this much because this is what Department of Veterans Affairs has provided us. So they can only make their decision on that paperwork still. Is that still going on?
Absolutely, Senator, and I think it's a misunderstanding. They shouldn't be sending... ComSuper are quite capable of looking at the evidence. Here's evidence, pick it up, look at it, make the assessment. I don't make medical assessments, that's not my job. I pick up paperwork, I look at evidence. So they're sending documents, just like they did to Joint Health Command, they're sending to them to MLCOA to try and get them to make a decision. What's happening is they shouldn't be sending them to MLCOA to look at evidence that they've already looked at. They should send them for an occupational capacity assessment. There is an international standard for occupational capacity assessments, and ever since I've started asking doctors to perform those assessments, miraculously, the decision can change from a C to an A with an occupational capacity assessment. If ComSuper want to know what the occupational capacity is, an OT can do it, an occupational therapist, an exercise physiologist, a physio or a specialist rehabilitation specialist, or a GP. The information's available, but sending them to MLCOA is just repeating the job that they're meant to do, and that is look at evidence. I hope that answers your question, Senator.
Thank you.
Thanks so much, Senator Lambie. Do any other senators have questions? Because I'm conscious if not, we should possibly move on to the next witness. If not, thank you, Ms Jackson, for your time today and your expertise and your submissions and all the contributions you make in this area and have made over a considerable period of time. I appreciate your appearance here today. And I would now seek to welcome a representative of Legacy Australia, if they could please come to the table. Thank you, Ms Jackson. Just a reminder to the committee, we're intending to break for lunch or suspend for lunch rather at 12:20 and return at 1:20. So I think we are on time for that. I now welcome a representative of Legacy Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, could you please state your full name and the capacity in which you appear today?
Thank you, Chair. I am Dr Mark Lax. I'm the Chair of Legacy Australia and I appear before you in that context.
Thank you very much, Dr Lax. Have you got an opening statement you wish to make?
Mr Chair, I do. I actually provided an opening statement to the Secretariat. You may have already seen it, but I'd like to...
I think that has been circulated, yes.
In the interest of time, I'd like you just to table that for the Hansard record, if you would, please. I have 2 disclaimers and I have a short other opening statement, if you allow me.
Sure, please go ahead, Mr Lax. Dr Lax, rather.
Before we begin, in the interest of full disclosure, I wish to advise the committee I'm a retired Air Commodore, having completed 50 years of permanent and reserve service. However, I am no longer involved with the Department of Defence. I think that's important that goes on the record. I'm also a recipient of the pension from Commonwealth Superannuation Corporation under the DFRDB scheme. However, I appear here not in a personal capacity, nor is my appearance related to benefits I already have or may receive from your consideration. Rather, I will be representing the interests of Legacy Australia and our beneficiaries. Thank you. May I now...
Thank you very much, Dr Lax, and I can confirm that the full text of your opening statement has been distributed to committee members, and we will meet later today to formally accept that as a submission and make sure it's forms part of the record.
I do have a short...
Senator Lambie, would you like to...
Pardon me?
Sorry, Dr Lax?
Yeah, I do have a supplementary statement which really summaриses the issues that Legacy has.
Sure, okay.
It won't take long.
Go ahead, Dr Lax. Sorry to interrupt you.
No, that's all right. Thank you. Before we begin, I'd like to thank Senators Lambie, David Pocock and the late Senator Jim Molan for taking up this matter of reversionary benefits for widows. The DFRDB, MSBS and ADF cover are defined benefit schemes where reversionary pensions for surviving spouses, partners and dependent children are available. But we have cases where this has not always been the case. Legacy would like to raise the matter of CSC withholding payment of reversionary benefits to surviving partners under these schemes when the veteran has died and because of mental health leading to domestic violence, the veteran and the partner were physically separated but still legally married. I now refer you to the Veterans Covenant, which states, and I quote, "We, the people of Australia, respect and give thanks to all who have served in our Defence Force and their families. We acknowledge the unique nature of military service and the sacrifice demanded of all who commit to defend our nation. We undertake to preserve the memory and deeds of all who have served and promise to welcome, embrace and support all military veterans as respected and valued members of our community. For what they have done, this we will do." Now, I read that covenant as a promise to respect and give thanks to families of veterans who too have served our nation by supporting their veteran partner, father or mother, throughout their life together. We must honour that promise. It states, "This we will do." Our experience is that family breakdown appears more common among veteran families than in the broader Australian community. To date, Legacy cares for over 28,000 individuals made up of surviving partners, children and youth, and disabled adults, including families whose veteran's loved one has given their physical or mental health. The Royal Commission finding into defence and veteran suicide also found that mental health issues are more common amongst veterans who have transitioned involuntarily, and often such mental health problems lead to family domestic violence, sadly. At issue, there are cases where the surviving family members no longer qualify for reversionary pensions because the spouse or intimate partner did not meet the Act's definition of spouse, that of requiring dependency. This dependency is determined to mean financial dependency and to be wholly or partially dependent, unquote. The DVA Act defines dependent as meaning dependent for economic support. So the interpretation has been that the surviving partner must be dependent on the veteran to receive a reversionary benefit, financial dependency. Modern superannuation schemes allow for binding or non-binding nominations to be made by the superannuant. With a binding nomination, the member specifies where their residual super goes when they die. This removes the discretion from CFC if a binding nomination is in place. Legacy wishes to highlight that Defence Force retirement and death benefits and military superannuation benefits scheme do not allow binding nominations, and CSC's decision criteria are not visible to families. This creates problems for the trustee when the time comes for disbursement, CSC. When the Superannuation Act of 1976 was drafted, the definition of a family was given to mean a man and a woman with or without children living together. Today, that is but one definition. Also in 1976, it was common for one partner, usually the woman, to be the homemaker. They often did not work, they did not have their own superannuation, and in many cases did not have their own savings. Back then, they were dependent on their veteran partner, legally, economically and emotionally. Contemporary households operate on more of a basis of mutual support and the sharing of roles of earning income, parenting and household duties. Partial dependence on each other with a strong degree of independence better reflects the current norm. It appears to us that the decision on whether the surviving partner is, quote, financially dependent before a benefit is paid is up to CSC to decide. The decision on dependency is based totally on CSC opinion on a case-by-case basis. Now, DVA recognised that a separated partner, where CSC does not, leading to divergent outcomes and clawbacks. There's a subtle difference. Legacy seeks to align CSC's criteria with that of DVA's by adopting a presumption in favour of survivors where there's room to be lenient. I'll summarise. Under the provision of the Acts Interpretation Act 1901, and if the Superannuation Act of 1976 has not been revoked, which I believe it has not, Section 8A of that Act, titled Marital or Couple Relationship, also still applies. Senators, I'd like to quote the paragraph 8A, which states, "For the purposes of this section, a person is taken to be living with another person if CSC is satisfied that that person would have been living with that other person except for a period of A, temporary absence, or more importantly, B, absence because of a person's illness or infirmity." It seems clear to Legacy that CSC can legally make a more lenient and compassionate decision regarding what we see as a fair entitlement. So what does Legacy seek from the committee? We ask that you consider and recognise domestic violence sometimes arises from the stresses of unique military service. We know this service places partners in different circumstances to the broader community. In the case of domestic violence, the couple cannot live together for safety reasons, which often requires financial separation as well. Second point, a review of the Superannuation Act in light of changes over the past 50 years to make it contemporary to Australian expectations and to clarify that dependency on a veteran at the time of their death is no longer a reason to deny a reversionary benefit to their surviving partner. And finally, if a review of the Superannuation Act of 1976 is far too reaching, then the committee may recommend smaller amendments to the superannuation industry (brackets supervision close brackets Act 1993 Commonwealth) and the superannuation industry (brackets supervision close brackets regulations 1994 Commonwealth) to remove this unfair and iniquitous dependency rule. Thank you, Mr. Chair, for allowing me that time. I now will happy to answer your questions.
Thank you so much for your opening statement. Senator Lambie, would you like to start with the questions?
Sure. I certainly will. Thank you. Thank you, Chair. I do forget about the families and that on this side of it, yeah, because it can get very, very complicated, very complicated, because you've also got the issue of, them, I see with the Vietnam veterans where their wife's been supportive for 20 or 30 years or the 30 years, and just recently, maybe over the last 5 years, the kids have all grown up they've separated,
Yep.
and then that veteran go and get married, and therefore that person is entitled to everything from that veteran. That is a real problem out there. Is that correct?
Yeah, it's broader than that, Senator. The definition of a family, and I've appeared before these hearings, I believe yourself before, is very broad. There's no formal government definition of what is a contemporary family. The mum, dad, 2 kids and a dog was maybe one definition, but that's probably quite old now. The best definition that's been given to me is I'll offer it if you're interested, is that a family is someone you love and someone that loves you and that you care for.
Okay, I don't think that definition's probably...
It's too broad, I know, but for the sense of this, the reversionary benefits apply to the legally married partner. The benefit is about 5/8 of the veteran's pension. It's an equation that's a bit complicated, but it's about 5/8 of the veteran's pension.
Is this not so this isn't complicated if they've got a will, is that correct? Unless somebody wants to contest the will.
I think it's more of a case of where the legally married couple, for example, I'll exclude the children's side of it for the moment, are separated because the veteran has mental health issues, maybe substance abuse, alcohol, whatever, and the partnership cannot live together, physically live together in the same abode. So whilst they're still legally married, I'll say, for example, the wife has to move out because the veteran husband is violent towards that lady, and consequently the aspects of financial dependency as applied by CSC and DVA come into play.
Okay.
So right now the widow, because we're assuming this is only after the veteran has died that they're claiming their reversionary benefit entitlement.
Okay.
So it's after the veteran has passed.
Yeah.
So it's a matter of them applying to ComSuper for the reversionary benefit that their late husband, in this case, would have earned. And then the ComSuper applies their rule as to whether they were, quote, financially dependent or not. And
I see. That's even once it's done the will, and you're gonna. So it's even with a will attached.
Oh, yep.
Then even with the will says, you're entitled to the rest of this. You're entitled to my, the goal, whatever you need to say in your will. Yep. It can still be contested.
Absolutely. We have in fact, I'll just point out that Legacy Australia has at least 202 families where the husband has been involved in domestic violence. We know there's a lot more simply because there's a lot of stigma attached to this with the family situation, and there's embarrassment. But you will hear later this afternoon from one of our legacy widows sitting behind me will present to you her circumstances, which really illustrates this. So yes, the will is one side of it, and that will be for any sort of properties and so forth, and go through probate. But this is basically applying for entitlements post the death of the veteran.
And what do they? Just can you give me an update of what the widower is if they were getting full entitlements? What exactly do they receive now in 2026?
Okay, so let's use the case where the male partner is the veteran and they're the perpetrator of domestic violence. I'll just use as a broad example. Yeah. They will receive their pension from their pension scheme. In this case, we're referring to DFRDB. And they will be in a family relationship. Now, if that family relationship breaks down because of the violence of the member, depending on the circumstances of each family, whether that the wife receives any benefits at all, because they could separate different bank accounts. It's extremely complicated. So the Act has been interpreted by CSC that they must have a financial dependency. So in other words, the wife in this case has to be financially reliant on the veteran, but that was 50 years ago. I mean, these days, partners have their own savings, they have their own superannuation and so forth.
Yeah, I can understand that with the Vietnam veterans and a lot of their wives, but anything after that was sort of, that's why I'm trying to get my head around it.
Well,
so
the modern superannuation funds allow for that. So this is really the older ones, which are no longer you no longer join. DFRDB, MSB, and ADF cover, I think it's called.
Clarifying point.
Yep.
That's where my head was going. So the defined benefit schemes,
yes,
have upsides and risks across the board. On the face of it, if your circumstances don't change and you do all the things that people anticipate will happen through your life without any issues, then the defined benefits are often much better in general terms.
Yep.
But the newer schemes, or the more commonplace schemes now, where you choose a scheme of your own choice and you put money in and your employer, Defence Force puts money in, then that money has a different different context. That money is your money and therefore is part of your estate and you bequeath it as you will. But you're talking specifically here about defined benefits,
yes,
where as soon as that person is deceased and they don't have a financial dependent, the money stops.
Yeah, the defined benefit scheme, as the members before spoke about the fact that there was no superannuation fund, it was just went into consolidated revenue. So I guess the legislators that developed the DFRDB Act allowed for the surviving partner of the marriage to get some benefit from their late husband or wife's pension. So this is only in the case where the veteran who has the pension dies, his life partner, in a legal sense, whether that's de facto married or so forth, would benefit from a reversionary pension from ComSuper. It was a sign of the times back in 1976 when it was designed.
Oh, okay. So hang on. I'm just getting very confused here. So the old DFRDB, to pay the new wife out or whatever, is now coming out of the ComSuper because there was never any, it was just consolidated. Yeah, how does that work?
No, ComSuper is the administrator, that's all.
Okay,
the CSC, yeah, they just administer the funds. And when let's say the veteran dies, the widow or the partner can apply to the CSC for their reversionary benefits. Now, in the most cases where the couple are still together, that's not a problem. It just gets paid automatically. It's reasonably straightforward. Advocates normally put in the forms to support the widows. In our case, we do, and that's straightforward. It's only in the case where the family has broken down because the veteran has been domestically abusing the wife, in this case, and they've had to legally not live in the same house. They had to move out and they had to sort of live separate lives but still remained legally married. Then when the veteran dies, because they weren't in a financial or wholly dependent relationship, CSC says they can't provide them the benefit, which they, I think, justly should deserve.
What do they base this on? How many years you've been together? Do they look at what is this decision based on?
It's just dependent. Whether you're financially dependent on the person or not, and if you're not financially dependent on them, then therefore it's not deemed that that you should get their pension.
Yeah. That's essentially it, and it's the way it's written.
Oh.
So we think it's unjust, unfair, and it needs to be rectified.
Oh, so if you don't work, if you're a woman and don't work, and that happens to you, you'll be right then. You've been financially.
Yeah. If you're a homemaker, I'll use that expression from those back then. I mean, it's really the time has now changed, so it's not the modern.
I understand that, but back then.
Yeah. So if you decided that your husband would be the veteran would be the breadwinner, if you want to use that expression, and you didn't work, you looked after the kids, looked after the home, whatever, you would be financially dependent on that person. Well, if that broke down, and the fellow moves out and does whatever.
So, Dr. Lax, if they are still living together, and they're married or de facto or whatever, and the couple are living together, but the veteran is actually financially dependent on their spouse as opposed to the other way around,
yeah.
do they then not get the pension as well?
No, it depends on their circumstances as well. Yeah,
So it's means tested effectively.
Well, I don't know how it works in reverse order. It's a good question. I can't really answer that one.
Okay.
Yeah, sorry.
Thank you.
Yeah, but yeah, no, I'll leave it at that.
Senator Dowling, did you have questions?
Just to follow on Dr. Lax, to what extent, because you've talked about a review of the legislation, to what extent do you think this is a legislative issue or just an interpretation issue that hasn't evolved with these changing family circumstances?
Yeah, I think it's either regulation or interpretation. I think the Act is, well, it was that, let me go back. The Superannuation Act 1976 is the baseline Act which the modern Acts have come to use. And of course, circumstances are very different now. I think it's a matter for CSC to be given the flexibility to make decisions based upon the circumstances, each case, which at the moment they've been hard and fast, as far as we can tell, denying the reversionary benefits when the circumstances are such that the husband and wife physically could not live together, and then the wife, who may not have had her own income, has to find some source of pension or other to live. So I don't know whether I'm being clear here. It's just that the Act says that back then in 1976, man and woman lived together. One was the breadwinner, one was the homemaker. They were financially dependent, simple as that. Well, that's no longer the case. And even in the DFRDB scheme, in the later years of that scheme, it's not the case either. Because DFRDB came in 1972, and I think it went through until more modern superannuation schemes were brought in. So really all we want is the fact that CSC take a look at compassionate reason, because we're not talking about huge amounts of money here. Back then, the veteran's pensioner, a digger who's probably left after, say, 22 years, wouldn't have a huge annual salary from his pension, and then the wife or the partner is getting 5/8 of that, so just over half. It's not like hundreds of thousands of dollars. So it seems to me that there is a reducing number of cases as we all age, but the ones that are out there need to be retrospectively compensated, because I think this is iniquitous.
Yeah, okay.
And has Legacy gone any? Have you tried to fight any of this in? Like, you've obviously got a problem with it to get it overturned. How far has Legacy gone with fighting this, or are you just doing it for independent cases?
No, every legacy beneficiary that falls into this category, we definitely fight for. We advocate for them. We look after their CSC claims, any compensation claims from other sources. And in fact, this afternoon you'll hear a case where the gentleman beside this lady is her supporting advocate. So yes, every case that comes to our attention where this has been, their benefits have been denied, we fight for, absolutely.
Okay. I have no further questions. Thank you.
Senator Grogan, do you have any further questions?
I'm fine, thank you very much, Chair.
Okay, Senator Dowling. All right. Well, I think we'll suspend for lunch now. Dr. Locks, could I thank you for your appearance today and your submission to the committee and your opening statement. As I said, the committee will convene later today to make sure we accept that opening statement into the record. We will now suspend for lunch. I'm going to suggest that we return at the time scheduled, so 1:20 p.m, so people have slightly longer for lunch, and we'll be back on the program then.
Thank you, Senators.
Thank you all. We'll now resume the hearing, and I welcome representatives from the Defence Force Welfare Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, could I please ask you to state your full name and the capacity in which you appear today?
My name is Christopher Lowis, L-O-W-I-S. I'm the Executive Director of the Defence Force Welfare Association National Office.
Thank you, Mr. Lowis. And would you like to make a short opening statement before we move to questions?
Yes, please. Chair, Senators, thank you for the opportunity to appear today. The Defence Force Welfare Association, or DFWA, is an Australia-wide organisation formed in 1959 for the purpose of promoting and protecting the welfare and interests of serving and former members of the Australian Defence Force and their families. A principal area of advocacy is in retirement and superannuation. The committee's broad terms of reference touch on many areas across the defence and veteran ecosystem, areas which, in our view, have not always received the necessary attention. The Royal Commission into Defence and Veteran Suicide primarily focused on the responsibilities of the Department of Veterans Affairs, but the concerns raised in submissions to this inquiry demonstrate a far wider range of issues affecting serving members, veterans, reservists and their families. Across the submissions made to the committee, including DFWA's, there are consistent themes. Widespread dissatisfaction with the operation of several military superannuation and pension schemes, and a clear identification of multiple systemic problems requiring rectification. DFWA's concern is that unless decisive action follows this inquiry, many of these issues risk becoming yet another report left on the shelf, acknowledged but not resolved. While numerous matters deserve attention, DFWA strongly believes that 4 areas stand out as requiring urgent, equitable and harmonised legislative reform. First, harmonising the tax treatment of invalidity benefits. Invalidity benefits across all ADF schemes, including ADF cover, were designed to be consistent or reasonably consistent in their financial outcome. Yet today, they are taxed differently. Veterans who serve side by side, who are medically discharged with near identical invalidity benefit payments, face vastly different tax outcomes depending on the scheme in which they belong or the date which they commence receiving their pensions. For those covered by ADF cover, which is anyone who joined the regular Defence Force after 2016, this means paying thousands of dollars more in tax each year than their counterparts in earlier schemes. These are individuals least able to bear such a burden, veterans permanently unable to work, many at heightened risk of mental health challenges and suicidality. This inequity is unjust and must be rectified. The second area is extending superannuation guarantee coverage to all reservists. Legislative changes have recently improved conditions for other casual and part-time workers across Australia, yet reservists remain excluded from the super guarantee contributions unless on continuous full-time service. Reservists play an absolutely vital role in fulfilling workforce gaps in our undermanned regular forces. It's been reported that on any given day, up to 1/3 of ADF members on duty are ADF reservists. There is no sound policy reason for excluding them from superannuation, and the gap is particularly detrimental to women and Indigenous reservists who already face lower lifetime superannuation accumulation. It's time to ensure that the same basic entitlements apply to all those who serve. The third area, ensuring reservists have eligibility for invalidity benefits through ADF cover. Unlike employees in all other Australian workplaces who must be offered death and total TPD insurance through their super scheme, reservists have no superannuation scheme and therefore no access to equivalent protection. ADF cover was established because it's often difficult and costly for ADF members to obtain such insurance privately. Extending eligibility to all reservists is a matter of fairness and basic workforce protection. The fourth area, fair indexation of all military pensions and related benefits. Even after passage of the DFRDB Amendment Fair Indexation Act in 2014, many benefits continued to be indexed solely to CPI, an approach that all parties at the time, all political parties, acknowledged was inadequate for reflecting the real cost of living changes. Benefits still linked to CPI include reversionary pensions, DFRB, DFRDB pensions for those under 55, not that there would be many of them, all MSBS pensions, including invalidity benefits, ADF cover invalidity benefits, and the accumulated employer benefit within MSBS, which cannot be rolled over until the age of 55, and it only grows at CPI. If members are prevented from rolling over this benefit like other Australians, then at a minimum, it should be indexed fairly. At this point, I'd like to make a quick correction to our submission. In our original submission, the inquiry started in the previous Parliament, in the term of reference B, which regarded enabling veterans to preserve savings, we mistakenly referred to employee benefit rather than employer benefit. We highlighted that it could not be rolled over and that members were penalised by comparatively low interest of the CPI. We proposed that members should have the same rollover rights as other Australians. However, DFWA is very well aware of the complexities of a legislative change in that area and suggested that if a rollover of the accumulated employer benefit was not acceptable, then at least it should be fairly indexed, which it's currently not. In summary, DFWA urges the committee to prioritise reform in these 4 areas. Each represents a clear and well-justified correction to inequities that have persisted for too long. Thank you.
Thank you very much, Mr. Lewis, for your opening statement and making that correction to your submission. I'll start with Senator Lambie, if she's available and ready to lead off with questions. Senator Lambie. I think you might still be on mute, Senator Lambie.
That better? Can you hear me now, Chair? Thank you. Good morning and thank you for coming forward. I'm not sure, but a lot of people don't realise that when you're a reservist, you get no superannuation paid in. That is a problem in itself. It's funny. They're a bit more. I know when I was in a reserve unit back in the mid-90s, it wasn't really spoken about, but I'll tell you what, they're onto it now, these younger kids, because they're a lot more up with it, obviously, and they've a lot more sand on this stuff. So do you think that's actually impacting the numbers that want to join the Army or the Navy or the Air Force? Because they go, well, you might pay me this per hour, but you get me no super. Sick leave's hard to get. And if you damage me, my goodness me, that's an even worse situation for them, because if a reservist is damaged, I take note it is a longer process for them, unless that has changed.
I'm not sure that it's a consideration for someone who wants to join as a reservist. They want to join the Army, and that's their driving motivation. I think it's probably a bigger consideration for currently serving members who are considering transitioning to the reserve force, and they obviously need to, or are more aware of the issue of superannuation.
Oh, I didn't think about it from that end. Okay, so they're probably not sticking around and saying you can go and stick your reserves where they fit then.
Well, they may
not enough push to say we want more reservists. I say this because on one hand, I've got the government of the day saying we want to build our defence capacity with people, and on the other hand, all this is going on the sidelines. So you think it is a problem from the other end when they get out and they realise that if they go on to reserve time, because I'm sure that many of them would, if it was a lot more lucrative. There is no lucrative in being a reservist, if there's one thing I know, because they don't get much for their chop back themselves, the member putting in.
I can't speak to that, whether it's a significant motivator or a significant consideration, but there would be a segment that it is.
And also, so when it comes to the ComSuper, they no longer get their members' benefit back anymore when they discharge. Are they still allowed to do that, or they're not?
With MSBS, certainly you can...
with MSBS, that's what I meant. Can you still take out the bit that you've paid into it?
You can roll it over into another fund when you get out.
Oh, I see. So you can roll your members' benefit out, but you can't roll their benefit out.
That's correct.
So, okay, so that nothing's changed there. We can't add to this pile here, nor can we take it out.
That's right, Senator.
Do you know of any other superannuation that is allowed to do that in the country?
I do not.
No, I don't. No, I don't know. That's why I'm asking you. I find it absurd that some of us, or some people, for many, have all this money sitting here and they can't roll it in to make more money afterwards because the government wants to hold it. I find that extremely detrimental financially to anybody that has served. You obviously, is that a problem?
No, Senator.
Okay. I noticed that the DFWA has recommended independent government external reviews.
Say again, Senator?
Have you recommended independent government external reviews, the DFWA?
We have. John Lois, who should be online, may be able to speak better to that area.
Can you hear me?
I can.
Right. I'm joining by telephone. All right.
Okay. So given John, given the past inquiries and reviews have been conducted in this area with very little change, what safeguards do you think are needed to ensure any future review actually delivers the meaningful reform, rather than just another set of unimplemented recommendations?
Sorry, Senator, I wasn't able to, due to comms difficulties, I wasn't able to hear the preceding conversation.
I wonder if you could state your name first, please, just for the hands up.
Yes, my name is John Lois. I am the Acting President of the Queensland branch of the Defence Force Welfare Association.
Thank you.
Yes.
So, sorry, I haven't seen the DFWA for a while. Do you have an expert in this area? Is DFWA running with an expert, a legal expert in this area? Or is this just things you've picked up? Is this just coming from you guys yourselves?
No, sorry, Senator, I wasn't able to connect into the preceding conversation. Which particular area are you talking about? Is this the reservist?
Yeah, well, I'm talking right across, the superannuation, the reservists, everything. What is DFWA's main issue? Are you fighting a heap of them in this area, of the superannuation area? Or have you got specific issues?
We have got specific issues. One of the things that we're trying to do is go for harmonisation of legislation, where where we have certain practices with for regulars, for example, but they're not reflected for reservists as well. And we're supposed to have a 180F concept. There is that. We have fair indexation for parts of DFRDB, but all the reversionary pensions are not subject to the fair indexation, the better of the CPI or the other formula involving the percentage of the average adult wage. There's a lot of inequalities between the various schemes, and that's the area that we're trying to, where, for example, ADF cover is excluded from the tax treatment which applies to those people on invalidity benefits from MSBS. We've got people serving side by side. They get injured. They've got exactly the same. They could get exactly the same Class A or Class B pension. One pays very little tax. The MSBS people pay very little tax. All new enlistees in ADF cover since 2016, they pay thousands of dollars a year more tax on exactly the same Class A or Class B pension. That's demonstrated, it is totally inequitable because the parliamentary intent was to have the invalidity benefits for ADF cover to be exactly the same or almost the same as MSBS. And that was successful. That was done. But since the Douglas decision and various other things, they're taxed even more. All the new enlistees since 2016, if they're medically discharged, they pay thousands of dollars a year more tax, and they're less likely to be eligible for things like family tax benefit, which is around about $7,000 a year for each eligible child. And we're talking here about the most vulnerable veterans, the ones who have been medically discharged, and they're most susceptible to mental health conditions and suicidality. And apart from those conditions, the fact that they've been discharged means that they've been rejected. That has a bad effect because they have sort of been rejected by the team and they also lose their team support. So it's an area which everybody recognises holds the most vulnerable veterans. And we're seeking to have the same tax treatment for all veterans.
Okay, explain to me explain to the committee what happened in 2016.
In 2016, ADF Super became the new superannuation scheme. Anybody enlisting from 1 July onwards in 2016 went into ADF Super. And because previously invalidity benefits, Class A and Class B, were all included in the superannuation package for MSBS, DFRDB, and even the predecessors of that, DFRB. They all had Class A, Class B, and Class C pensions. And actually, it was a harmonised legislation. There was no disadvantage going from one to the other. There was only a couple of $100 difference a year in the actual amount. The way they were calculated was slightly different. When 2016 came in and we had ADF Super, to get this, and that's all coupled in with the super guarantee, super funds were obliged to offer death and disability insurance. And that's when ADF cover was made available. Now, ADF cover was funded by the consolidated revenue. And the reason for that is, and it's clearly stated in all the documentation and even on the website now, that ADF cover was going to give virtually exactly the same as MSBS, and it was being provided through there would be no charges. It would be funded through consolidated revenue. And the reason for that is, and it's stated very, very clearly, is that such insurance was beyond the reach of veterans because of the nature of military service. You could not get that insurance that's available to all other Australians. So because of the unique nature of military service. So ADF cover provides that, and it's a separate insurance scheme. So you've got people serving in since 2016. They can put their super funds, could go into what is offered under ADF Super, or they can put it into a fund of their own choice. But if they put it into a fund of their own choice, a commercial fund, whatever, another industry fund, they still retain ADF cover because the other funds just cannot offer suitable insurance for them.
Okay. Okay, and that comes at no extra cost?
That comes at no extra cost, no. They don't have to, and that's exactly how it applies to MSBS as well.
Okay, but you're saying it is coming at a cost though?
Well, any payments are funded out of consolidated revenue.
Okay. So there's no extra financial cost, but what's the human cost? What's the negatives? What's the negatives in doing that?
What's
the problem with ADF cover, I guess? What's the problem with the ADF cover? What's the problem with the ADF cover?
The problem is with ADF cover is that it is taxed differently to MSBS.
Why is that?
Well, it was. That's just the way this was raised last year in Schedule 9 when they had the tax change laws. I think it was 23, 29 tax change laws, where the Douglas decision, which applied to DFRDB and MSBS payments, invalidity benefit payments after 2007, were classified as disability superannuation benefits because of the court case, the Douglas decision, and that decision did not flow on to ADF cover. Now, part of the reason for that is that this was a result of 3 or 4 years of test case litigation, which started in 2017. And in 2017, there were no cases from ADF cover to take before the courts. So only DFRDB and MSBS were covered by the court's decision. Yeah. Now, this was, it was subject to an inquiry last year or the year before, I've forgotten which, with Schedule 9 of the, was one of the omnibus bill covering about a pile of tax treatments going right across the board. And we argued then that ADF cover should be included to be covered in the Douglas decision, to give the same benefits as the Douglas decision. Now, I was speaking to people yesterday. I was at the transition seminar in Brisbane, and have 2 people in front of me. One's being medically discharged under MSBS, and the other's being medically discharged under ADF cover. And they weren't exactly the same invalidity benefit payments, but they were taxed differently, and the difference was thousands of dollars. These are people.
Why they tax? Can you explain the tax? Why they tax differently? What's the difference between the tax regime for both of them? What's the difference?
The tax regime, it all goes back to the Douglas decision, which was the taxation of invalidity benefits from DFRDB and MSBS. Now, the legality, it's complex tax law, but basically, all of those invalidity benefits are capable of being reviewed. And in fact, one of the cases in the, and what that means is they can be decreased, they can go to zero. And we had one of the veterans involved in that had 8 reviews of his pension. And he went from an A to a B to a C, which is nothing, it's virtually ceased. And they went up to B, and it went up and down like jigsaw, and he didn't know, he didn't know when the next blooming review was coming. And that was over a period of about 4 years. So it is not a lifetime pension. You try and go and get a mortgage, and what's your income? Oh, an invalidity benefit, it's not lifetime. Well, the mortgage lenders get a bit twitchy about things not being lifetime pensions, right? It's not a lifetime, and that was established. Now, under tax law, if it's not a lifetime pension, not an income stream, it is a lump sum. And the payments are actually a series of lump sums. And lump sums coming from a defined benefit scheme have a significant tax advantage than an income stream. They're taxed totally differently. There is a thing called the disability superannuation benefit, which applies to all Australians, and most of those on a Class A or a Class B can apply for that, and it requires 2 medical practitioners to say that they are unlikely to ever work again due to their training, education or qualifications. And you heard earlier on today the advocates representative making mention of this particular thing. But they also introduced another aspect of it too, about when the person gets out and tries to get total permanent and disability insurance, they can't. That is another aspect of the problem. But it is a fact of life. You know, and the other thing is, because of the nature of it, you will get people who are a veteran who might have 3 kids. Under MSBS, they're most likely to be eligible for family tax benefit, which can be around about $7,000 a year per child, eligible child over while they're eligible while they're at school. And that could be $20,000 a year. Now, if you have got a veteran who is injured, medically discharged, is limited in the work they can do, and his wife possibly, or spouse, and forget the gender because we get cases of both, is a carer, you know, it affects eligibility for carers allowance too. And this can be a lifesaver for those people. And they miss out. It's a no-brainer. I don't think there'd be any politician which would introduce a system where you've got people serving side by side, getting the same pay, end up getting the same injury, and they're classified as unable to work, and they end up getting an invalidity benefit almost exactly the same. Now, they're within $100 of each other over a year, yet one is taxed more than the other. Now, 2 people I saw yesterday, one enlisted 3 weeks before the 1st of July, and one enlisted 2 days after the 1st of July. And that's the tax treatment of both were totally different. Now, it defies all sorts of reason. They should be treated the same.
That's because one's claiming invalidity payments, which is the Douglas decision. Is that correct? The Douglas decision said you will, because of the invalidity payments with the Douglas decision. The Douglas decision,
yeah. Yep.
Yeah,
the Douglas
determined
decision
that the
just applies for 2 different laws. Yeah.
Yeah, so the Douglas decision determined that the payments from an invalidity pension were lump sum payments, not regular income. So what you're telling me, so therefore they got to pay less tax, is that right, from the Douglas?
Well, generally, yes. There's a sliding scale. It depends. How much less tax depends on a thing called the disability superannuation benefit. And essentially, the longer a person has got to serve, who could have served, means the greater is the tax-free amount. The greater there's a larger tax-free amount in their invalidity benefit. So for people who are within 5 years, say, of their retirement age, the difference is not much at all. But if you take a 22-year-old and he's got another umpty years, you're looking at around about 90% of the income is tax-free.
Thank you. Thank you, Chair.
Thanks, Senator Lambie. Senator Grogan, have you got questions for this witness?
No, I'm just digesting that. Senator Dowling may have some questions.
Senator Dowling.
It was actually just related back to the reservist superannuation issue. And my understanding is it's always not attracted superannuation guarantees because reservist income is tax-free unless it's continuous full-time work. But I've seen arguments that it would be better removing the tax-free status and actually implementing the superannuation guarantee instead, and that would actually be more attractive because the tax-free status and income taxes have changed, that it might only be providing maybe a 30% benefit at best versus attracting superannuation. So does the association have a view about whether superannuation would be better than the tax-free status for reservist income?
Senator, both can exist at the same time. There's no policy reason why reserve pay that's tax-free you must not get superannuation on. There are
but
plenty.
That is the reason, though. That it's because it's income taxes.
It's how they've defined the salary that is like reserve salary with reference to the Income Tax Assessment Act, a table in there. There are many tax-free or many people, many workers in the Australian economy that earn tax-free income that receive superannuation on that income. There's no reason that the two can't exist.
No, I accept you'd probably prefer both. I think that's a fair position. I'm just saying, is one preferable to the other?
I can't answer that, Senator. I don't think we can.
I've just seen other advocates in the space say that they'd prefer to have the superannuation benefit rather than the tax-free status.
I can't answer that. I think DFWA's position is that reservists can get superannuation and remain tax exempt.
Sorry, why did the tax exemption start in the first place? Or I assume that's just a historic piece, or was there a rationale to it? Given that a lot of them have other jobs, and so the tax implications would be quite intense, maybe.
Yeah, I believe there was a period in the past where they removed the tax exemption of reserve salary, and it had a very negative impact on reserve recruitment retention issues. It's an enticing proposition. The value proposition for joining the reserves would be.
Yeah, because if you had a full-time job and you're sort of closer to the top or second top tax bracket, then your additional income would sort of be quite. You'd be losing up to half of it in tax. So
yeah,
that was the
and same for younger reservists who may be doing university, having that income as tax-free means it's not reportable and doesn't impact things such as Commonwealth rental assistance, for instance. So.
Mr. Lois, it's Senator Sharma here, Dave Sharma. You've raised a large number of issues here, and I appreciate you doing so, and you've made a large number of your submissions quite broad-ranging. What do you consider to be the highest priority, though, or the lowest hanging fruit, or what would give you the most satisfaction, I guess, to see change of the various things you've outlined here today?
From the association's point of view, can't name one, but I would name two. The first being ADF cover being included within the Douglas taxation so that it can receive the same modification for disability invalidity benefit that MSBS and DFRDB superannuation or invalidity payments post 2007 receive. And the second would be to extend the superannuation guarantee to reservists.
Extend the superannuation guarantee to reservists. Okay. But you would want, just to follow up on Mr. Dowling's question though, you would want the tax-free treatment of reservist pay to continue?
Correct. So we understand that the superannuation being paid to reservists would come out of the defence budget, so it costs more, whereas the tax-free, we believe, is a completely separate issue, and it goes to revenue for the government. It's I guess you call it different buckets of money.
Yeah, one's revenue foregone, one's expenditure, but yeah, different pieces. Okay, thank you. That was all the questions I had. To any of my colleagues, Senator Lambie, Senator Grogan, Senator Dowling, any further questions?
Not
for the
me,
witness?
Chair, thank you.
Well, thank you for joining us today, and thank you for the submission on behalf of the association as well, the Defence Force Welfare Association. We will now move on to the next witnesses, and just for the information of the committee, we are going to proceed first to Ms Cook, supported by Mr Wills, and then we will move on to Mr Jones. We're going to do them separately rather than in individual blocks. I believe that's been communicated to you already. Thank you once again for your time, the Defence Force Welfare Association, and we'll move on to the next witnesses, please.
Thank you, Senator.
Thank you.
Chair's heavy.
Because he was on the next coming.
I believe we've got, sorry, I'm not there in person, but Ms Cook and Mr Wills present at the witness table.
Yes.
That's great.
Thank you.
Thank you. Thank you for appearing before the committee today to share your personal stories, Ms Cook and Mr Wills, and I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. I should also remind you that witnesses have a right to request to be heard in camera should they wish to give evidence to the committee in confidence. For the Hansard record, could you please just state your full names and the capacity in which you appear today, and then I'll invite you to make a short opening statement should you wish.
My name is Patricia Nancy Cook, and I'm here as a person of experience with superannuation versionary pension not being given, being denied.
Thank you, Ms Cook. And Mr Wills, you're there to support Ms Cook, I understand?
Yes, I'm here. My name is Ian Wills from Canberra Legacy. I'm here to support Mrs Cook in providing evidence to the committee.
Thank you so much. Ms Cook, would you like to make an opening statement?
Yes, thank you.
Please go ahead.
Okay. Well, first of all, I thank the committee for allowing me to present my submission, and Senators Pocock and Lambie for responding to me, and Mr Wills, who has been a tremendous support. I feel like I've been very unfairly treated with the decision made by CSC in refusing my application for my husband's reversionary pension when he died in 2019. The Superannuation Act of 1976 relies completely upon financial dependence of the spouse. I was working right up to and past my husband's retirement, and I was the one helping him when he had severe medically diagnosed mental problems, as well as coping with domestic violence. I had to find a place for him in keeping with the dignity of his experience in the Vietnam War, as well as look after myself and the children. We were running away, sleeping on many floors, including the pets. I feel like I'm a victim of the CSC decision, and I would like to explain what happened in my case. This has happened to many widows in differing circumstances, and these problems will not be addressed until the Superannuation Act is changed, of 1976 is changed or looked at fairly. My husband trained for 15 months in America to work on the Ikara missile. He commissioned the destroyer HMAS Perth in Boston. We married in 1966. He went to Vietnam in 1967 on HMAS Perth for combat. His ship was hit 3 days after it arrived. He was a metre away from the blast. He had shrapnel wounds but alive, and the sailor next to him was very badly wounded, could not walk. His ship spent the whole time bombing the coast of North Vietnam for more than a month at a time. He was sleeping under the gun turret with blast and noise, also working with Navy helicopters, picking North Vietnamese out of the water, wounded bodies, and searching those carrying bombs on their bodies. He managed okay to start with once home, but then started to drink heavily and became violent. He left the Navy in 1972 as a Chief Petty Officer, Weapons Electronics Engineering. When the children were younger, he had us crawling around on the floor trying to put us in the hall cupboard to hide us from Charlie. Then it escalated to me having a loaded rifle in my ear for a couple of hours a few times. He tried to take my protective services officer's son-in-law's gun out of his holster when he bent over to help him up from falling when he was inebriated, then ringing him in the middle of the night, threatening them both, saying he wouldn't know what the gun was. When drinking, he never slept, so we were petrified. There was far more violence and more injury to me. He stopped drinking for 11 years in 1978, but social phobia, depression and mental illness progressed without the alcohol. In 1989, he became more violent and was drinking again. He missed the Navy. We sought help through VVS, Vietnam Veterans Counselling Service, constantly together. He decided to try to pull himself together again after a severely bad episode and get medical help. He rented on and off some of the rooms, like in Barton and places like that in those days, during this time, but I ended up having to take out a DVO as he kept turning up in the middle of the night, violent and drinking. The police were there often to help, and they were great. So I was paying the mortgage at this stage so he could pay the rent. I went to a solicitor and put a financial order together to help us both, not a legal separation. In 1994, I took out a loan in excess of $110,000, paid out all our debts and gave him money for a deposit. We decided we could look after each other even if we had to live in separate places for my safety and the children. I still have our plans. He was constantly in touch regarding their education, and we helped each other out all the time financially. After the DVO, we were able to see each other socially and be together, saw each other at work, and both became registrars in separate faculties at the Canberra Institute of Technology, Bruce and Woden. His mental health kept spiralling downhill. CIT paid for 6 weeks hospital treatment for his problems, but it was no good. He medically retired in 2003 as a TPI pensioner. He stopped turning up to HMAS Perth Navy get-togethers, became a hermit with outsiders. I have medical documents from psychiatrists and a psychologist specialising in PTSD, war and related depression, showing all of these problems. He died in 2019. I was his executor, looked after everything, brought the Navy back to him at the funeral. I'm still having counselling, for PTSD, and both the children were and still are very badly affected. I think the way I have been discriminated against because he suffered mentally from his war service is very unfair and hasn't been looked at properly. Mr Ian Wills has copies of all the documents regarding his health, our financial matters and letters between us. Thank you for letting me speak. Okay.
If I could support...
Thank you. Thank you so much, Ms Cook. Mr Wills, you're free to make a brief statement, but we do also want to get to questions, so if you could keep it very brief.
Yes, I'll keep it short. Dr Lax has already provided the background to the situation that Mrs Cook found herself in.
Yes.
And it's now well established that military service can cause psychiatric illness in some individuals. Psychiatric illnesses can place strains on domestic relationships that mean that families need to adapt to the circumstances. Mrs Cook's case is a good example. Mr Cook had to live separately for safety of the family, and when Mr Cook self-medicated excessively with alcohol following his injury in the Vietnam War. Mrs Cook and their family maintained a strong relationship with her husband despite these service-related circumstances. She provided financial support to him and took responsibility following his death. But she was deemed not to be financially dependent upon Mr Cook. Correctly, but unfairly. Her application for their contributory superannuation benefit was repeatedly denied, despite the Superannuation Act making provision for absence due to illness or infirmity. Unfortunately, in recent years, CSC has followed a strict interpretation of the Act that families must be financially dependent on the member. Now, I've noted in the civilian world, different rules would appear to apply. A colonial first state document states the law only allows you to nominate individuals who are financially dependent on you, but they add, or have an interdependency relationship with you at the time of death. And I've provided senators with a copy of how that is defined. I suggest that for defined benefit recipients under the Commonwealth legislation, a similar provision be applied to service families covered by Commonwealth superannuation legislation, if it is unable to interpret the existing Act in a better and more logical way. Thank you for your interest in addressing this grossly unfair superannuation treatment of the families of our veterans.
Thank you so much, Mr Wills and Ms Cook. We'll begin with questions. Senator Lambie, did you wish to go first?
No, not at this stage, thanks. Thank you,
okay.
Chair. We don't, okay, and we don't have Mr Thornton on this one, do we? We lose
no,
Mr Thornton?
No, he's appearing, I think, at 2:20.
Oh, okay, great. Okay,
yeah,
thank you. I see what's going on here. Great.
Yeah, we've
questions for him. Thank you. Thank you so much.
Senator Grogan or Senator Dow?
Sure. Thank you for coming in and sharing your experience. We really do appreciate it. So the dependency piece that that gets assessed, what level of engagement have you had in applying for that? So did they go back to your husband left the Defence Force in 1972? Is that right?
That's when he when he left the Navy. He resigned from CIT in 2003.
Sorry, CIT?
Canberra Institute of Technology, sorry.
Yep.
2003.
Okay, so he was in the forces of some sort?
He was in the Navy.
Yep.
From 1960, I think, until 1972.
So did he receive a benefit from 1972 onwards when he
Well, he
left
actually,
the Navy?
I think, rolled in his money over at one stage there. We were together.
Yeah.
I can't remember the date, I'm sorry. When he came out of the Navy, he went to work for Wormald's and a few places like that.
Right.
And so he would have taken that part of his superannuation out, right?
Because he would have been in the first scheme.
DFRB.
Yep.
Yeah. And then, so this that I'm talking about now is only from his employment at the Canberra Institute of Technology and maybe Department of Mineral Resources and a little bit before that. It's only that part.
Okay, right. Thank you. That's great. No, that's all I've got. Thank you so much. It's really helpful.
Mr. Wills can tell you how many people we've been to, including CSC twice, and then Senator Gallagher, and Jim Molan was trying to help us before he died, and we were starting to get somewhere, and then you talk about it now.
A bit of background. In 2013, there was a federal court case where the federal court interpreted the need for financial dependence. And since then, we've been attempting to have that redressed. At the political level, we've spoken to or corresponded with Ministers for Veterans Affairs on this issue, and we were assured that Commonwealth Superannuation Corporation would treat every case differently and that the federal court case would not be necessarily the gold standard. But unfortunately it has become so, and since 2013 we have repeatedly attempted to have the matter addressed. As recently as the last 2 years, we've sought the help of the Minister for Finance, and we've been unsuccessful.
And I think the most important thing here is that each case is different. And I mean, I did support him tremendously, but they're not, it doesn't seem to be that we're actually looking at the differences. It's just being cut and paste. 1976 dependency, you know what I mean, all the way through. And the 2 times we've appealed, that seems to be what it is with all the documentation. And everything is different, especially, I don't know very many people that were not working most of the married life to try and get a house. Do you know what I mean? So dependency, to me, especially when I was trying to help him so much, we were helping each other, really. But, I mean, in the end, it was awful, you know. Anyway, I can't say it anymore.
In fact, the financial dependence was the other way in this particular case.
Yeah,
that was a question I asked earlier, and we'll be...
Yeah, I can't say it anymore professionally, sorry, that's what I was trying to say.
You're doing a great job.
Thank you.
Mrs. Cook, you really are. Thank you so much. Thank you, Chair.
Mrs. Cook, could you please tell us on what you've missed out on?
I'm sorry?
Could you please tell us what you have missed out on financially because of what's happened to you?
Well, I wouldn't say anything about when we were...
I could probably help here.
Okay.
She's been denied the reversionary pension that she and her husband contributed to throughout his service. He contributed to the superannuation.
Looking after each other.
And he drew his superannuation from DFRDB when he retired. But instead of his wife being entitled to the reversionary benefits on his death, she was denied that benefit.
Wow. Okay.
So it's only that.
Well, and you've had what? You've had the finance minister look at it. You've had Kate Gallagher look at it.
Yes. And it's only that small part from when he pulled himself together a little bit and got himself a job in the government when he was very clever, don't get me wrong, and then eventually downgraded himself a bit and went to the Canberra Institute of Technology in keeping with the fact that he wasn't very well mentally. So it's only that part that we're looking at the moment that we've been denied. And I mean, up until after he left the Navy and was working for ICARA project management and places like that, we were together, just a minute, I've lost it, sorry. So, you know, I mean, there was times when he wasn't working because he was living in rooms. I had to try and work out a way to make sure that he had somewhere to live and I had somewhere to live safe. So that's what I went along to a solicitor, and I've got all the documents where I set it out that I would take out this loan, and I paid out his money to give him some money to put a deposit on. And all the way through this, he was really mentally unstable. It was dreadful. So, we kept trying and kept trying to keep together and do these things, helping each other. But I have been denied, on his death, that part of his superannuation.
Correct.
There is another.
So what part of, sorry, what is that? What is that? What part of what sort of earnings is that? That part of the superannuation?
I think it was about 150,000.
Look, I'm sorry, I can't give you a figure, but it's a fortnightly payment that she would be in receipt of.
Okay,
a government guaranteed fortnightly payment.
Yeah, it is a guaranteed fortnightly payment. What do you estimate? Do you have any idea of what that fortnightly payment would be?
No, sorry.
No.
Because we've been refused so many times. We haven't got that far, have we?
No.
This is not just for me, this is for other people in a similar situation. Because people don't understand what it's like being with... Today I'm dealing with the things that, and I was in those days, the things that are so important now, the domestic violence and all of that sort of thing. And I've worked out, I put in, the other one, the suicide, I put in a submission to that, saying that I think one of the most important things when veterans come back is somewhere for them to live, somewhere for because they come back and their families don't know what's happening to them. They're too young, the children, to split and buy a mortgage each. They don't have the money because they're young usually. And so they're either, one of them is sleeping on the streets or drinking too much or, not living properly. So what I tried to do was make sure that he had somewhere to live as well as I did, and we worked really hard at that. That's all the stuff that Mr. Wills has got on record, all the documents. I kept everything, even the letters he wrote to me all the time, how much he missed the pets, the beasties. And I mean, it's terrible when you're going through all that because you're too young and you don't know what's happening around you. Anyway, that's me.
So can I ask, did you have periods of living together and living apart? Or
just while he was trying to get himself established in the beginning, when he started drinking again after that 11 years of sobriety, he took himself away, went to get help with AA. I worked with Al-Anon for 5 years. That's for the families. But he took himself to AA and he got sober for 11 years. But then even after that, he went on a downhill run. So he found somewhere that he could just be on his own. Like in Barton, you could just rent a room. And there was one in the main street here in Canberra. And he lived there for a little while and we just supported each other and he came and went. But that's how it was. And then he bought himself a unit over in Northside and worked at Bruce, and I was living in a home at Waniasa and worked at Southside. But we were together a lot because we were both registrars.
Thank you.
That's about any more questions? It's hard to tell it all because it's so emotional.
Yeah. No, I appreciate it. It's really difficult.
Yeah.
Thank you so much for coming.
Okay. I hope it helps somebody else.
It's
been very kind and powerful of you to share that, Ms. Cook. Sorry, Mr. Wills, did I interrupt you?
No, that's it.
That's it, thank you.
Senator Dowling, did you
questions?
Wish to ask any questions?
No, thank you. That was very helpful.
Thank you.
Okay.
Well, thank you so much, Ms. Cook and Mr. Wills. We are now going to move on to the next witness, who I believe is Mr. Jones, appearing via video conference. Mr. Jones, I understand you're online and ready to go, so I'll just need to read a quick preamble. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to a Senate committee has been provided to you. And I also remind you that witnesses have a right to request that evidence be heard in camera, should they wish to give evidence in conference to the committee. Mr Jones, can I just please ask you to state your full name and the capacity in which you appear today for the Hansard record, and then I will invite you to make a short opening statement.
I think Mr Jones may be on mute.
Yeah, you might be on mute, Mr Jones, if you could unmute yourself and then identify yourself.
Okay. Maybe we should suspend while we get Mr Jones on.
We might just suspend briefly whilst we're just going to suspend briefly whilst we endeavour to get Mr Jones unmuted and online. appearing before the committee today. Just for the Hansard record, would you please state your full name and the capacity in which you appear, and then I'll invite you to make an opening statement.
Okay, so David James Jones. I guess I'm a 35-year veteran, now retired, and I guess understanding the shortcomings of some of the pension outcomes. So
Thank you. And would you like
appreciate
to make
the opportunity and your time to sit through this. So thank you very much.
That's quite all right, Mr. Jones. We're looking forward to hearing from you. Would you like to make an opening statement at all before we move to questions?
Yes. So this is probably going to take 5 minutes. Is that all right?
5 minutes is fine. Yeah, if we could keep it to that, though, no longer than that, that would be appreciated. Thank you.
Okay. So DFRDB, so that's the scheme, I believe it fails the most basic tests of what a pension or a superannuation scheme should deliver. It's not fit for purpose because it exploits members by taking their contributions without crediting them. It shifts all the risk onto members, and it siphons off potential returns for the Commonwealth. So put some meat on that bone. No recognition of the contribution. So in my case, that's $400,000. There's no earnings on those. There's no tax concessions. Members are left to pick up the tab on the employer contributions, which in my case is about $98,000. The result is that a member, or the benefits, are split in a ratio of $2.50 for every dollar investigated in the Commonwealth, and $4.50 goes to the members. So a salient point here, $320,000 is on overpayment of pension reductions. So I've looked around the public space for documentation that provides advice that you would lose that amount. While it's understood there's 5.5 of salary over the career period, when you add the 320,000 to the 400,000, which is my contributions, that's 720,000 that I've contributed, and it only comes out at about 1.8 million in benefits. So I haven't included the superannuation guarantee in that. I'm just comparing all of the other superannuation schemes out there. So all of the other schemes, they'll either give $6.50 or $7 back to the member, just as a comparison. Let me move on to the tax element. So we're taxed on our contributions. We're taxed on the capital when it comes back to us in the form of benefits. The CPI adjustments are also taxed, which means that the purchasing power that they propose to provide are then taxed, so you don't receive it. So you don't make any gains there. And then you've got obsolete retirement mortality data. So what that means is we're using 60 to 62 ABS mortality data for a person, which gives you a life expectancy of 72 years. And because of that constraint, it means that we're paying elevated pension reductions for that period. And then they don't stop there, they continue until you die. So that's your 320,000 going back to the Commonwealth. The OECD says Australians should receive 24% tax discount on their super. DFRDB delivers 34.5% tax surcharge. So that's a 59% percentage point disadvantage relative to what the OECD considers is an appropriate retirement policy. Let me touch on the accountability side. So I've run projects and I've managed budgets in defence. The PGPA, the Public Governance Performance and Accountability Act, provides very little flexibility on how you do that, but there seems to be a whole lot of flexibility in how they manage our superannuation. So from that point of view, Section 15 By failing to govern in a way that promotes proper use of public resources, it's using 1960s data, while members will live up to 85 years of age, so that's not proper. Section 16, by maintaining no system of risk oversight over the actuarial assumptions. So we're looking at 50 years where everything has just been frozen and left to just bad data, because one of the aspects of the current discount rate in Schedule 3 is it's a 4.8% interest is charged when people take up those lump sums. Section 21, by acting inconsistently with government policy, the government uses current data for its own liability calculations, but members are using Schedule 3. Section 26, by failing to act in good faith towards members through permanent reductions based on manifestly obsolete data. And Section 5, by failing to meet high standards of governance, performance, accountability and ethical management. So I've been to CST to address these issues and they have not been resolved. I've been to CCDA, so Capability, Compliance and Defence Administration. Those issues have not been resolved. I've been to the Australian National Audit Office to get them to look at the details here. They have not been resolved. And I've been to the Joint Committee of Public Accounting and Audit, and crickets from them. So those issues have not been resolved. So what that means is $720,000 invested over a 57-year period, and what I get out of it is a high tax bill. I guess I'll stop there and pass over to you for any questions you might have. But what I'll just say to close out is...
Mr Jones, we might move on to questions because we're a bit late getting onto this item, and I know Senators have questions.
Okay,
thank you, Mr
fine.
Jones. Senator Lambie, did you wish to begin? No, none for you. Senator Grogan.
No, thank you.
No, I think Mr Jones has covered everything as far as I'm concerned. Thank you.
Okay. Senator Dowling?
Could I just, I know that Mr Jones referred to double taxation. Could you just elaborate specifically what you mean by double tax?
Sure. So what's occurring is I pay tax in my salary, which is the deductions that go to CSC for the pension contributions. So they've been taxed. They go into the Central Revenue Fund, and then they come out as essentially benefits. The tax has already been paid on that, and I'm paying tax again. So that's the double taxation.
Okay. That would work quite differently to any other superannuation arrangement by the sounds of it.
Yeah, so what they're trying to do is to basically, instead of allocating those contributions back to the member, they're saying, oh no, we're just going to follow the formula for the benefit, and it's got no traceability. But there are you know, the Douglas full court case law, which looked at characterisation of where the actual tax comes from, so the substance rather than the form, says if it's taxed, then it should be a non-concessional contribution, so it should be tax-free. But that doesn't happen in this case.
Okay. Thank you. I understand that point. Thank you.
Can I just clarify something? It's Senator Dave Sharma here, Mr Jones.
Yes.
In your submission, you make a reference to members contributing from after-tax income into the DFRDB. Is that right?
Yeah, so it comes out of our salary, right? We pay tax on our salary. It's in the actual statute, the DFRDB Act, that we have to pay out of salary. It's written in there as salary, and it's defined as in the definitions. We give the fund contributions and we give benefits in return, but those benefits are taxed.
Yeah, no, of course. But so the DFRDB, it's a defined benefit scheme, right? I'm correct there, aren't I? But,
yes, it is. But I mean, it was updated
I just assumed that Defence as the employer pays directly into the scheme from, I mean, it doesn't come out of someone's pay after they've paid tax, and members pay after they've paid tax. I presume it comes out of gross earnings from the Defence Department as the employer. Is that not right?
That is correct.
So it comes out of after-tax income. So you get your pay slip. I mean, I know the DFRDB is not operating anymore, or not for active members. But if you were an active member on the DFRDB, you would get your pay slip. You'd have all the PAYG tax, your income tax deducted, and then you'd see a deduction in the after-tax income for a contribution to the DFRDB.
That's right.
Okay, thank you. I wasn't aware of that. It's rather curious. I'm afraid in the interest of time, Mr. Jones, and because we're a little late starting the session, we do need to move on, but I do want to thank you for joining us today, and apologies for the technical difficulty which meant you were late to join.
All fine. Thank you very much for the opportunity.
Now I believe we have Mr. Thornton and Mr. McFarlane appearing. Mr. McFarlane and Ms. McFarlane, I believe, are in the room, and Mr. Thornton is on video conference. Could I just have that confirmed?
Yeah.
Yes.
Yeah, we've got Mr. Thornton online and Mr. McFarlane in the room.
And Mr. Anderson.
And Mr. Anderson's online as well.
Okay, very good, thank you. So just for the interest of time management for everyone here, we've got this block until 3:20. We are obviously keen to hear from all witnesses, Mr. McFarlane, Mr. Thornton, Mr. Anderson. I will ask you to invite you to make opening statements, but could you please keep those no longer than 3 minutes so that we can move to questions afterwards. And before we begin, could I please ask that you state your full names and the capacity in which you appear? And just a reminder, if you're not actually speaking, please put yourself on mute. We might start with you, Mr. McFarlane.
Good afternoon. I'm Andrew Bruce McFarlane. Been known all my life by the middle name of Bruce. I'm a retired warrant officer, ex-Air Force, retired about 30 odd years ago, and a member of the DFRDB scheme.
Thank you, Mr. McFarlane. And Mr. Thornton, you're on teleconference, is that right? Mr. Anderson, if you're there, could you just unmute yourself and say your name and your position for the record?
Yes, hi, my name is Jason Anderson. I'm medically discharged former ADF member.
Thank you, Mr. Anderson. Is Mr. Thornton there? I can't actually see him or notice him on the screen.
Yes, he is.
Sorry, Senator. Sorry,
Go ahead, Mr. Thornton.
I don't know what's happening here.
Sorry, I think I've probably got the best visibility here, so excuse me, Chair. Mr. Castle and Mr. Anderson, can you please put yourselves on mute? And Mr. Thornton, can you please give us your opening statement?
Senators, the issue that is being raised here today is a complex issue that delves not only into DFRDB. I wish to speak just very briefly about that, but I want to give the committee the benefit of over 6 years of research into matters surrounding invalidity and the social security aspects of a very large, complex architecture of benefits and entitlements. And it will help solidify your own knowledge of some of the previous witnesses, the testimony by previous witnesses, which I must admit, given my medical situation, I didn't get the chance to fully listen to. So, in any case, my testimony in regards to the invalidity and the social security side of things will be critical for your total understanding. Thank you.
Mr. McFarlane, I might ask you to make an opening statement, given you're there in the room, and I'll go to Mr. Anderson.
Thank you. Chair, Senators, ladies and gentlemen, thank you for the opportunity to appear before you today. When you look at it from a distance, as I, and I'm sure most other ADF personnel did when we were young, the DFRDB scheme looks quite attractive. It's only when you get into the lived experience of retirement, or if you examine it more closely, do you discover the betrayal that has been imposed on ADF veterans. What was proposed by the JES Committee and sold to ADF personnel is not what the DFRDB scheme became. This is because changes were made to the administration of commutation and the indexation of pensions. It is doubtful the government fully understood the implications of these changes, and these underhanded changes were never clearly communicated to ADF personnel. I will not go back over the details of these changes, as this is well covered in my written submission, which I hope you've had the opportunity to read. What I will say is that the effect of these changes is that the purchasing power of my DFRDB pension has reduced by almost 50% since my retirement. I strongly implore you to consider changes to legislation that will amend the DFRDB Act to cease the reduction of benefits when members who commuted reach their Schedule 3 life expectancy, and restore members' current rate of benefits to where they would be if their benefits had been fully indexed in accordance with movements in the average weekly earnings from 1976 until the 1st of July 2014. Thank you.
Thank you, Mr. McFarlane. Mr. Anderson, please make an opening statement.
Chair and committee members, thank you for the opportunity to appear. My name is Jason Anderson. I'm a medically discharged former ADF member appearing on behalf of my family and more than 60 veteran families who have documented similar impacts. The issue I raise today affects invalidity benefits paid by the Commonwealth Superannuation Corporation under both MSBS and DFRDB. In 2024, Parliament enacted amendments inserting section 1099 AAA into the Social Security Act intended to address the consequences of the Douglas decision. The 24 to 25 budget allocated $11.9 million for implementation. My concern is that current reporting processes may not reflect what Parliament intended. CSC calculates a tax-free component of these invalidity benefits for taxation purposes. Section 1099 AAA requires that same tax-free component to be used when assessing social security entitlements. However, CSC reports the Services Australia via an outdated Centrelink schedule that asks whether the superannuant has a special reduction amount. In documented cases, including my own, the amount recorded is nil. The practical result is that the tax-free component does not appear to be reflected in social security assessments. When I raised this with Services Australia, I was told the tax-free component is for tax purposes only. However, section 1099 AAA expressly incorporates that component for social security purposes. For my family, this has resulted in an impact of approximately $300 per fortnight and 2 debts totalling more than $10,000. Across the 60-plus families who have contacted me, members report cancelled or reduced payments and debts ranging from $5,000 to over $50,000. The legislative framework exists. The issue I respectfully raise is whether current reporting processes align with section 1099 AAA as enacted, and if not, what steps are required to ensure correct implementation. Thank you.
Thank you so much, Mr Anderson. I understand we have Mr Nathan Castle has joined us as well. If that's the case, Mr Castle, would you mind just identifying yourself and saying your name and the capacity in which you appear for the record?
My name is Nathan Castle. I'm here to discuss the retrospective medical discharge application and the process.
Thank you. Yep. Thank you, Mr Castle. I know you've made a submission as well, so I appreciate that. Thank you. We might I know the senators have many questions, so we might move straight to questions. Senator Lambie, would you like to begin?
Yeah, thank you. Thank you, Chair, very much. I'll come to you first, Mr Thornton. Mr Thornton, can you tell me what's going on between your payments, which I'm sure will be like Mr Anderson's Centrelink, and what's going on there, if you don't mind?
Yes, can you hear me, sorry?
I can, yeah.
Okay, great. In order to answer that question, Senator, I think it would be important just to give you a quick history lesson, because it will actually fill in a lot of gaps in the committee's knowledge or understanding of how things have transpired. So when the introduction of the super system came into play in the late 80s, the government decided, and the Parliament as well, decided to introduce a quite complex arrangement of superannuation, which would then offset the amount of compensation payable, and then also an interaction with Social Security. And there were a number of reviews done. One was the Poll Review, which very clearly explained the deficiencies with the DFRDB scheme that needed to be updated so that it, together with MSBS and the other Commonwealth schemes, would comply with the government's new superannuation system. In 1992, the government introduced a whole range of sweeping reforms in order to pick up a number of aspects of the architecture that was already well established in the mindset, the political and policy mindset of Justice Cole and others. And what they did is they decided, with regards to invalidity, and I'll get to the Social Security side because this is important to understand, they actually curbed abuse. The whole purpose of this was to curb abuse where people were rorting the medical and invalidity side of the superannuation and tax system, particularly those who were taking early retirement through redundancy or and other measures. And they were effectively getting letters of medical retirement for nothing more than a sore toe or a runny nose, and that then actually entitled them to full invalidity concessions, tax concessions and the like. So the government stitched all of that up. But when they did so, they decided to actually create a very specific set of rules, a divergent path, if you like, for those people who were genuine medical retirees. And so they then created what was known as a disability superannuation pension. Now, that is separately defined in the 1936 Tax Act. And in order for you to actually obtain that benefit, you had to meet the very strict conditions of 2 doctor's certificates certifying that you were effectively totally and permanently incapacitated for superannuation purposes. Now, the de jure standard for that, as far as the military is concerned, is met by a Class A invalidity benefit. And in one of the submissions that I'll provide you after this hearing, you'll see an excerpt from Justice Cole's report where he clearly explains that. So then the critical thing here is that they also created a concessional tax environment that would work on the basis of, sorry, I'm going the wrong way, worked on the basis that if you retired early, then you would receive, the vast majority of your benefit would be tax-free. And on the other end of the scale was a 15% tax offset on the total taxable component. So as you move through the time continuum, then the tax-free component of that future service that's forfeited because of invalidity becomes less, and as you approach your compulsory retiring age, which is age 60 for most schemes, then it peters out, and the only thing that's left is actually the 15% tax offset. So the critical thing here is that Section 27G of the 1936 Tax Act worked out that invalidity component, the tax-free amount. It was supposed to be an undeducted purchase price that went into Section 27H of the same Act. And what that did is it actually calculated, in Section 27H of the 1936 Tax Act, it calculated what is known as the total undeducted purchase price, or the deductible amount. Now, it's the deductible amount that is the critical issue for the social security side of things. And so between 1992 and 2006, that arrangement had been put in place. The problem is that CSC never actually applied the law correctly. From the point of exit, I can prove to the committee, contrary to what you've been told before, that all of these benefits manifest as a superannuation lump sum in the first instance before they are paid. And so therefore, CSC has not borne faithful allegiance to the law in applying those tax concessions in the first instance, which then feed into the social security side of things. So in the 2006 C+ super system, they then slammed those two sections of law together, and they created what is now known as Section 307-145 of the Income Tax Assessment Act of 1997. And that component represents both the tax-free component for tax purposes, but also the deductible amount, the total deductible amount for social security purposes. And so that deductible amount is deducted away from all source income in order to leave the net assessable income for means testing purposes. Now, the unfortunate thing that's happened since 2023, is that the government has knowingly deceived the Parliament by producing false narratives about the fact that they were always meant to be superannuation income streams. And now that that's been passed, and they've effectively coerced you into and hoodwinked you into legislating theft, because the theft of 32,000, the tax concessions for 32,000 invalidity recipients, 10,000 of whom are veterans, and of that 10,000, 4,000 are in receipt of Commonwealth invalidity benefit, such as PSS or CSS or PSSAP. And I'm a case in point. So the...
Mr. Thornton, just in the interest of time, because we do want to hear from the other witnesses, could I ask you just to conclude your answer?
So,
other questions, please.
Okay, so the critical thing here is that what's happened now is that we've moved from the false narrative that it's always an income stream to now the false narrative that the calculations in 307-145 are for tax purposes only. Now, that is totally false. If you do a proper statutory construction of the law from 92 through to now, what you'll see is that it produces the tax concession, but the deductible amount, or what's now known as the special reduction amount as of 2024, for the purposes of all of those veterans, under the Douglas decision. But the fact is that there's been 32,000 people have been diddled out of the tax concessions and the social security entitlements they should have received, and the rest of Australia still gets these concessions. But your own employees, your own former employees, have been diddled out of those concessions, and they form a very the policy reason for this was that back in '92 they recognised that if someone was totally and permanently incapacitated, they would never come back to the workforce. And so that's the reason why they made sure they wanted to ensure that they had concessional tax treatment so that they could save in a concessionally taxed environment, and also to be able to draw on the social security system so that they could buy a house, save for their retirement, so that when they got to the point of retirement with their contemporaries, those that did not crash and burn medically, then they would be able to live in relative comfort with the rest of them. So thousands of veterans and tens of thousands of public servants have not received what they were supposed to receive. And the fact is that the Douglas decision, as I've said in previous documents and in the testimony at the Community Affairs Committee, the decision is plainly wrong.
Mr. Thornton, I'm going to ask you to conclude there because we do want to hear from the other witnesses. I know senators have other questions. Okay. Senator Lambie, have you got further questions for the other witnesses?
I have. Maybe you, Mr. Anderson, if you can, you've got kids and stuff.
That's correct.
Can you tell us what effect, obviously, that's doing with your Centrelink and all that sort of stuff? Can you explain that very basically to us, please?
Yeah, sure. Basically, my wife's carer payment is being reduced by approximately $300 a fortnight.
Why is that?
Because Centrelink are counting my entire military invalidity benefit as a taxable payment when in fact they should be only focusing on the tax-free component. Or they should not be incorporating the tax-free component, I should say, sorry.
And this come out of some of that Douglas decision as well. Was that involved in that Douglas decision? This stuff as well.
Yeah, basically the government introduced the Act in 2024 to counter the Douglas decision, and that's where we're at today because of that.
Right. Okay. So basically they don't want it as a tax-free. You can't just put it over here and say, I'm sorry, I'm getting this because I'm permanently impaired. This is my compensation, but you're also including this on top of here to work out your amount. That's what's going on here.
Yep, that's correct.
Yeah, okay, that's what I thought. So in other words, this promise of we're going to get compo, it won't make any difference to your tax. It won't, if you're completely wrote off, it's never going to affect you on Centrelink. Is now affecting you on Centrelink. And so what you're telling me back in 2024, that was now been reversed or set in, because I know that was the Douglas decision. He could see discrepancy between that because one, it was for compo. It is there for us for the rest of our lives. That's what we're getting. We're not working for it because we can't, because we're injured.
That's right.
So Centrelink is now taking that and going, well, actually, too bad, so sad. You're actually earning this much when they shouldn't be. Is that correct?
Yep, that's correct. And it's not just my family. It's 60 other families. There are people that are being told that they're not eligible because they have too much income. There are people that are being underpaid and there are people that are receiving debts.
Yeah, I just want to make sure that I understood that because that's how I understood. When you're given that is quarantined. In other words, that is yours. Nobody else needs to know your business.
That's
and
correct.
It shouldn't be used as a tool for Centrelink to knock back payments.
That's correct.
Correct. So it's not just your kids that are paid. It's now your wife who's had to slow down her work because she's become a carer for you and you're still losing out.
That's
because
correct.
of your service.
Yes, that's spot on. Thank you, Senator. Couldn't have said it better myself.
Right. That's all. That's the only question I have. Thank you.
Can I just add to that, please?
Sorry, no, I'm going to move to the other senators, but we will come back to you, Mr. Thornton. Senator Grogan.
Thank you, Chair. Mr. Castle, I'm very aware we haven't really heard very much from you. Is there anything you'd like to contribute from what you've heard from the other witnesses?
Not regarding the issues that relate to me. So the issues that relate to me is regarding the retrospective discharge application and process. And the three main issues that I've came across is the length of the process, which is 12 to 18 months. The second is that my initial application got classified as a Class C in August last year. Though my DVA claims got finalised in November of 2024 with 105 points, which is 80 points is the maximum. You're entitled to gold card maximum financial compensation. The reason that CSE classified my application as a Class C was that my current injuries doesn't relate to my medical documents at the time of discharge back in 2015. I voluntarily discharged back then. The reason is, which has been quite extensively proven and shown throughout the Royal Commission, is just the toxicity of the Defence Force at the time. Of course, I underreported my psychological and physical injuries. And yet DVA accepts that you can get injuries and claims submitted that don't fully reflect your medical documents, but CSE does not. And the third issue that I've arose dealing with CSE regarding these issues is pretty much what DVA was like about 10 years ago with how they speak with veterans. I found the interactions with CSE to be dismissive and adversarial, which makes the process of veterans feel as though that they're attempting to exploit or rot the system and that we're a burden, rather than that what we're doing is trying to seek rightful recognition of service and related injuries. You know, I'm required to go to, I live in Bundaberg, I'm required to go to Brisbane every Monday for specialist treatment. I have physiotherapy, chiropractor, psychological. I'm required the use, as of September last year, of a service dog. I initiated tertiary studies in 2020 and had to cease tertiary studies in 2023 due to my mental illnesses and ended up in psychiatric hospital. Now, I just don't understand how one arm of the government can accept all these injuries and CSE is the flow-on, retrospective discharge / the pension is the flow-on effect from DVA, and yet they don't take anything into consideration.
Is it a problem because you weren't medically discharged? Have you had that changed at all?
Well, I was actually medically downgraded for 4.5 years. I fought 3 medical terminations because the ADF could not medically manage me because I was the first person to receive a eye treatment, a cornea operation. Yeah. Because when I came back from Iraq in 2009, I was legally blind in my right eye and I had pretty crappy vision in my left. And Defence was like, oh, we didn't cause it, too bad, so I'd catch you later. Well, I appealed it and I fought it and I received surgery in 2012. And because I was the first person to receive collagen cross-linking in the ADF, they just didn't know how to medically manage me. As of 2017, members of the ADF now with bilateral keratoconus can serve throughout the military.
Yeah, I understand.
I just got sick of being in an infantry battalion for over 4 years, being fit, smashing my body physically, doing the pack marches so I could be ready to go, and always being told, oh, no, wait another 12 months for the MEC-RB, another 12 months for the MEC-RB. We'll keep you at this medical classification. That is mentally draining and depressing in itself.
I understand that, but in the end, you got a medical discharge?
No, I didn't, because I just left before the termination.
Have you had that overturned?
The Class C is what that is, saying that, yes, you should have been medically discharged. Well, I've got given all the entitlements by the ADF as a medical discharge, so I've got extra money to help separate into civilian street, because literally my discharge got put on held in abeyance 6 days before my termination date, whilst they were seeking further guidance about my treatment.
Okay.
Yeah.
I have no more further questions.
Cool.
Senator Grogan, you had some further questions?
Just one question for Mr McFarlane. The Schedule 3 life expectancy, that assumes that in general you're only going to last till 72. Is that correct?
In broad terms, yes.
In broad terms. Yeah. What would be the difference, like just again broadly, in terms of the differential, if as you have proposed that the repayment of your commuted amount stops at that point?
Well, it would, at present, it's the only loan, if you treat it as a loan, that you never ever can repay, and yeah, it's totally unacceptable, really, in terms for people to be forced to keep paying a loan back once they've paid the amount back. The computation is 4 years of your pension at the time of retirement. I'm struggling. I'm trying to remember back to how much the lump sum was, and I'm sorry, I'd be guessing at this stage.
No worries.
I don't have the figures there. Yes, so we've been repaying that since I retired in '93, and now I've gone past the Schedule 3 life expectancy, so I've finished paying it back. So my pension should revert back to what should be upon retirement, but it doesn't.
Great. Thank you very much. Thank you, Chair.
Thank you, Senator Grogan. Senator Dowling.
Nothing, Chair. Thank you.
Senator Lambie.
Yes, that's fine. I'll continue to ask some questions here. Mr. Thornton, I did notice with that Centrelink you wanted to pop in and say something quickly. What, did you still want to do that?
Yes, please, Senator.
Yeah, that'd be good.
So, if senators remember, I just spoke about the fact that there's been a number of false narratives being produced. The false narrative now is that 307-145 of the Income Tax Assessment Act of 97, which that's the section of law that produces the disability superannuation benefit calculations. It produces the tax-free amount and the deductible amount or the special reduction amount. They are both synonymous. They're not separate. They're not mutually exclusive. And what's happened is that the false narrative now is that the output of 307-145 is for tax purposes only, and as a consequence, CSC have been directed by government, and I have this was said to me over the phone by the team leader of the pension section, they've been directed by government to fill the form out incorrectly, producing false certificates, which is a breach of Section 87 of the Crimes Act, in basically saying that everybody's deductible amount, the tax-free special reduction amount, deductible amount, is $0, because that's only been calculated for tax purposes. So the problem now is that's supposed to be filled out, the Centrelink schedule is filled out and feeds back to Services Australia, and they have to take that that advice from CSC as gospel in their calculations to work out the net assessable amount for means testing purposes. So it's diabolical. There's a real issue here, and Mr. Anderson knows intuitively what I'm talking about here. He's seen it firsthand himself, through not only his own eyes but through the eyes of 60 or so recipients. And my own son, a TPI veteran in his own right, applied for a disability support pension after a number of failed attempts, applied for a disability support pension on the 20th of March 2023. And that has still not been resolved because we've been forced to take these BS decisions through to the Administrative Review Tribunal, and there seems to be very clear capture, bureaucratic and political capture within that organisation, because they just continue to reproduce whatever Sir Humphrey has told them against all the evidence that's been put in front of that particular review process. And it's been frustrating to the nth degree. And Mr. Anderson, I think, could share a number of horror stories of other recipients that have been directly affected by this. One young lady, not much dissimilar to yourself, Senator Lambie, when you first retired. And in fact, let me just say this to everybody that's listening: they should download a copy of Senator Lambie's book, because it seriously reveals the true nature of what young people who've been jettisoned out of the system, who feel betrayed and the system has failed them. The problem is Senator Lambie thought there was just DVA and defence that it did. But the truth of the matter is that CSC didn't do its job by providing Senator Lambie the tax concession for her Class A invalidity benefit and the deductible amount that should have fed into the means testing for Centrelink purposes. I can tell you now, if you had have received what you were entitled to, then you wouldn't, I almost bet my left earlobe, you would not have stepped out in front of a vehicle. You would not have felt the despair to step out in front of a vehicle. Seriously, people need to read Senator Lambie's book. I'll take a commission later.
Thank you, Mr. Thornton. I have to say I'm still out of sea, so we'll be coming back for that. But yes, and I was also told I could be a security guard or go and make coffee, which is still very hurtful. Same crap, different day, I suppose.
Exactly.
And it is nothing worse, and I can imagine the more years of service when you get CSC saying, you know what, you're quite capable of being a security guard or pouring coffee, take your pick. That's what your real millions of dollars of taxpayers' money being spent on us resolves in. That's about as far as the CSC will go. It's not much has changed. Mr. Anderson, would you like to give me some more stuff about Centrelink? And is there anything else you want to add about that? Because I know this is an area. Is it just Centrelink as well at the government departments where we're losing out because we have to say, you know, this is earned money rather than actually this is quarantined money? This is quarantine money that we get for the pain and suffering. And you're not entitled to it. Nobody else is either, because it's a little bit of stuff that we get on top of the pain and suffering that we have to live with for the rest of our lives. So do you have anything else you want to add to that, Mr. Anderson, that maybe you didn't get in?
Yeah, I just wanted to add that I've raised this with both CSC and Centrelink, and it seems to be a catch-22. CSC are aware of the issue. Their schedules are outdated. They can't update these schedules unless directed by Services Australia, and Services Australia don't believe that the schedules need to be updated. So we're at a crossroads, and that's how it's affecting, again, not just my family, but at least 60 other families that I'm aware of.
Yeah, okay. I thought the numbers were bigger than that, or is that just what you've got on your books?
60 of the people that I've been able to identify myself through social media outreach. CSC have verbally told me over the phone the number is much higher, but I don't have access to their data. So
I'm glad they do. I'll have to FOI them then. Okay, thank you. I don't have any further questions unless you wanted to add anything else, Mr. Anderson.
I'm fine. If you have any further questions, I'm happy to answer them on notice.
Okay. Thank you. Thank you. Thank you, Chair.
Thanks, Senator Lambie. Senator Grogan or Senator Dowling, any further questions from you?
No, I'm fine. Thank you, Chair. Just to thank everyone for sharing their stories today. It's really very helpful, and thank you for your service.
Can I just, Senator Grogan, can I just answer a question that you had with regards to the life expectancy tables?
Sure.
You had a question of one of the other witnesses. I'll provide a copy of my submission of several years ago, and in the back of that you'll find a comprehensive set of life tables that clearly show the differentials between what happened, the life table from 1962 right through until now. Now, the thing with the DFRDB legislation, and again, this is a massive error by the CSC, because I spent several days in the National Archive seeing whether at any point in time had CSC or Defence notified the government that that the life tables have changed. And so basically the life tables have been out of date since 1975. And as a consequence of that, those benefits affect not only the individual but their reversionary spouse.
Yeah, I'm
so,
aware of that, yeah.
So that document is very comprehensive and actually gives you a breakdown of the actual the dollar impact on my own circumstances. So that will help to answer your questions there.
Thank you. The Secretariat has advised we can get that submission. That would be great. Thank you very much. Thank you, Chair.
Thank you, Senator Grogan. Thank you to Mr Thornton, Mr Castle, Mr McFarlane and Mr Anderson for your appearance today and your submissions. And as the Deputy Chair just outlined, we are able to take further submissions. So, Mr Thornton, if you wish to table that earlier report you flagged, the committee would welcome that. We are now going to suspend for 10 minutes for an afternoon tea break, and when we come back, we'll hear from the Department of Defence. Thank you once again to the witnesses who have just been appearing. I appreciate not only your time today, but your service to our country.
Thank you, Senator.
Thank you.
Thank you.
I now welcome representatives from the Department of Defence and the Commonwealth Superannuation Corporation. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to committees has been provided to you. For the Hansard record, could I please ask that you state your full names and the capacity in which you appear today, before I then invite you to make an opening statement, should you wish.
Thank you, Chair. Kai Blackman, First Assistant Secretary, People Policy and Development, the Department of Defence.
Thank you, Mr Blackman.
Chair, Adam Natheim, Chief Customer Officer of Commonwealth Super Corporation.
Thank you, Mr Natheim.
Good afternoon, Chair. Brigadier Kirk Lloyd, Director General, People Policy and Employment Conditions, Department of Defence.
And
Thank you so much.
Good afternoon, Chair. It's David Wilton, Head of Defence and Veterans Liaison at Commonwealth Super Corporation.
Thanks, Mr Wilton. Do any of you have an opening statement you wish to make, or is there a joint statement?
We both have independent statements, Chair.
Okay, please go ahead.
I'll kick off then, Chair. Thank you. Good afternoon, Chair, committee members. I'm Kai Blackman, First Assistant Secretary, People Policy and Development from the Department of Defence. I have with me Brigadier Kirk Lloyd, who is Director General, People Policy and Employment Conditions. Thank you for the invitation to attend today. Brigadier Lloyd and I are here as witnesses on behalf of the Department. Defence welcomed the opportunity to provide a submission to the inquiry to the operation of the military superannuation schemes and pensions in March 2025. We are here with our colleagues from the Commonwealth Superannuation Corporation. Defence has policy responsibility for the defined benefit superannuation schemes for ADF members. These are the DFR-DB scheme, the MSB scheme and the ADF cover scheme. Defence also has policy responsibility for the defined contribution superannuation scheme, ADF Super. Defence is responsible for facilitating legislative changes to these superannuation schemes as they occur and ensuring that the legislation is operating as intended. The Commonwealth Superannuation Corporation administers the defined benefit schemes and is a trustee of all ADF-related super schemes. Defence and CSC have a collaborative working relationship which is focused on providing quality, empathetic and consistent support to ADF members, veterans and their families. Our recent joint focus has been on seeking to improve the education and awareness of schemes for members. Defence does not wish to provide any further information outside our original submission at this time, but welcomes any questions from the committee on these matters. Finally, we acknowledge that superannuation and specifically defined benefit schemes are very complex. We look forward to supporting the committee in its inquiry today and will endeavour to respond fulsomely to your questions. But noting complexities, should it be required, we'll come back to the committee with more detailed answers. Thank you.
Thank you, Chair. Again, Adam Natheim, Chief Customer Officer for Commonwealth Super Corporation. The Commonwealth Super Corporation, like every other Australian super fund, exists for a sole purpose, that is, supporting the retirement and insurance outcomes of its members or their dependents if the member passes before retirement. Although CSC may be perceived as limited in what it can do, due to its sole purpose and core responsibilities to its members, we are very conscious of our important place in the broad veteran ecosystem and of our contribution to the wellbeing of our customers, including serving ADF members, veterans and families. We acknowledge the unique nature of military service and the sacrifices made by many, and we welcome the opportunity to assist the committee.
Thank you very much, Mr Natheim. We'll go to questions then. Senator Lambie, did you wish to lead off if you're there?
Sure, thank you, Chair, very much. I'll just go to I'll just go to ComSuper, if you don't mind. ComSuper, I'm just wondering, sorry, Mr Natheim, sorry. I'm just wondering, why these, what's the average time length in there to get these gradings done, the A, Bs and Cs?
Yeah, thank you, Senator. In answering that, I'll provide some background. Since 2018, CSE has experienced a significant year-on-year increase in claims, particularly for retrospective claims. In 2018, the number for the year received was 288, and in the last financial year, 24-25, it was 1,117. We, of course, have experienced delays in achieving the standards that we would like to achieve, because at the same time as those retrospectives were climbing, the initial invalidity claims were quite stable, so still at a very high level. In early 2024, CSE and Defence conducted a review of resources and processes to manage the rise in retrospective invalidity claims. Defence supported CSE through some additional budget to the tune of about $600,000, and that assisted us in bringing more staff in to assist with those claims. The original prediction, and we had a backlog of 1,398 at the time that were over 18 months old, the original prediction was that would take us 2 years to get through that backlog. The reality is, from the commencement of that, we've closed 97% of the claims that were in backlog, so 1,354 have been closed with 44 remaining outstanding. That's typically because we're waiting on more or additional information to be made available to us. While we've been able to close those claims that were in backlog, we also closed an additional 1,672 retrospective cases. So with the work between CSE and Defence, we've been able to put resources in place to help us limit what that backlog looks like. I should point out we're still receiving about 100 retrospective claims a month at the moment, and we can't see that that's going to stop in the near future. And this is part of the ongoing conversations between Defence and ourselves to understand the load that comes through and how we manage that load between us.
Sorry, when you had 200, you went from 288 to 1,100, so it was 288 last year, was that the year before?
No, 288 was 2018.
Oh, 2018, yeah.
And the 24-25 financial year was 1,117.
Okay, and so how many more staff does the office have now compared to what it had in 2018?
We've got 5 more claims managers.
You have 5 more...
Sorry,
you have 5 more claims managers. And how many claims managers did you have in 2018?
2018 was 46.
46. So back then you had 46, and since then you've got an extra 5 for an extra... my maths is a bit thin here. For about 800 extra people you've put on, let me guess, 5 claims managers. Are you kidding me? I'm sorry, but I can see where your problem is here. So Defence was quite nice and give you $600,000. Good on them. I don't know, I could get this wrong, Defence, but I thought only about 3 years ago you actually gave back about $500 million because apparently you couldn't spend it. Anyway, and did you get any extra from the government? So you got 600,000 from Defence. What about the government? Because really, I'll see where your problem is here. You're doing the numbers with me.
Yeah.
Yeah, huge discrepancy. I know that's not your fault. You don't get to employ them, but seriously, I think the committee's worked out the problem here today. You are understaffed. Thank you. I have no further questions on that, unless you have a point to make about all that. No. Okay, so we have a staffing problem. I want to come to Defence now. I think that it would be really valuable if the committee could get from you guys any correspondence between the DFRB, was it the DFRB and the DFRDB? DFRDB. So when you went from that first superannuation scheme to the DFRDB, could you please supply the material that you used to to say that to members? Any correspondence that Defence may be willing to give out that may help the committee during that period of time?
Senator, just to clarify.
I want to see whether what was written and the laws were the actual intent.
Yep.
So
Senator, just to clarify,
yes.
When the schemes changed and the new scheme was opened, you'd like to see the correspondence which Defence members at the time...
Yeah, sorry, I want you to, that you were giving your soldiers. So I want to see what paperwork or what, what pamphlets went out. There would have been pamphlets at the time saying, you go over to this scheme, this is how it's going to work, all that sort of stuff. Any correspondence that I can get between the minister at the time in Parliament, and anything through Defence would be helpful. Anything else related to that matter around that time that you guys were involved in? I mean, you would have been having talks about going from one scheme to the next.
We will take that on notice, of course, Senator. That was back in 1972, so I'm not sure where our records would be.
I'm sure there'll be something on it. It was a pretty big move. I'm sure you'll be able to find something. I'm sure that, they'll find it. Anything that you can find would be helpful.
Copy, Senator.
That seems to be the debate on that they got hoodwinked, probably weren't told the truth. So I'd just like to see what evidence, if there will be some that you can find, please, from that period back that you can supply. That would be helpful. We'll start from there. I have no further questions at this point in time. Thanks, Chair.
Thanks, Senator Lambie. Senator Grogan, you're in the room. Would you like to ask any questions?
Yes, please. Thank you, Chair.
Go ahead.
Thank you for coming along. Obviously, we've received a lot of submissions and we've heard a lot of evidence today, and there are some common themes. So I just really want to put them back to you. And I know that you've been listening in for a lot of the session today. There were a range of there's been a range of commentary about the quality of the delegates who do the assessments in CSC, about a lack of training. If we take the number of humans versus the number of submissions as, what it is, and go to that issue of the level of training and support for those officers. Could you maybe take us through that?
Yep. So first of all, I want to make sure we're very clear these are not medical people. They're not making a medical assessment. They're receiving medical files and information with which to assess the person into the level of invalidity. The amount of training that they're provided, a person when they're employed or moves into that particular team, they're provided a number of months' worth of training to understand how you distill down all of that medical information to then position it into one of the class levels of the disability. There's oversight of them from their leadership group to make sure that the decisions are being made correctly, and a quality mechanism to make sure that they're being managed in the appropriate way. And that continues for some time before the person's deemed to be competent to be able to make decisions without that kind of level of oversight. It is an area where it's a high stress environment. Claims teams across our industry do typically have to deal with stresses in that environment because they're hearing about a lot of circumstances which are pretty tough, and we acknowledge that they're not in that situation of that the veteran is in, but hearing and working through that each day is difficult. So we often see people having to come out of those teams to have a time away from it, or in some cases a level of full-time break from that kind of work, which then means we're also training new people to take that role on. So as I said, the level of training is several months. We have also where we have complexity, we can also lean on some external medical assessors who will help us understand some of the complexity that they're dealing with. If they're not understanding the nature of the claim or the nature of the injuries or illnesses, where they can avail themselves to some additional support to make sense of it all. Again, so that they're not having to try to assess something that they're not qualified to do.
Mm. Yes, because if they're assessing the medical information and they're not medical people, that kind of brings me to what level of appeal, what's the percentage of appeals?
It depends on the outcome initially. And I will say that over the last 3 years, the level of Class A's have been 89%, 89% and 92%. So Class A's are actually quite high.
So about 89% are appealed?
No, 89% are a Class A. So you're typically not going to get an appeal from somebody
nowhere else to
getting
go from
that
there,
kind of outcome. So where we do get the appeals are, of course, the B's and the C's. The appeal rate, I might take that one on notice. I've got a figure in mind, but I don't want to mislead the inquiry.
Sure.
I'm happy to come back on the actual appeal rate.
I'm also interested in the success rate of those appeals.
Yep, we'll bring that back. Absolutely.
How many, how many make it, how many are upheld as they were originally. The other thing that was brought up was a sort of an accusation that the medical advice is ignored or overruled. Is there a situation where the assessors would overrule some medical evidence?
The legislation says that we have to use the medical evidence to determine the level of invalidity. So I would say no.
Do you have a sense of why that accusation is being put?
Certainly where claims don't get the outcome that people are looking for, there's always debate around what it is about the claim that's not getting the outcome. So I'd say that's the kind of reasoning behind why people would say it's being overruled.
Okay. And if somebody appealed on medical, saying that the medical information hadn't been appropriately assessed or in their mind, what action would you take through an appeal?
Yep.
So does the appeal go to a different person, to a different classification of assessor, or does it just go back into a generic pool? Does the same person reassess what they assessed in the first place?
Yeah, so typically it would go back to the original assessor. The way we manage our claims is that you have an assessor dealing with a particular veteran, so they're going to have contact most directly with them. So typically they would say, I'm not happy with the outcome. They will bring in other people in the team to determine whether there's a different outcome that should have been found or...
Always? So if there's is there ever a case where one assessor would provide their assessment, an appeal is sought, and it just goes back to that assessor to reassess what they already assessed?
I think what you're asking me is, could that assessor do it without reaching out for assistance? Given the volume of claims that we do every year, because it's also on the civilian side, it would be very difficult for me to say absolutely not, because we do in excess of 5,000 claims a year. So, but it's not how we want people to operate. I'm not saying that somebody hasn't operated that way. The veteran also, or the advocate also, but most particularly the veteran, has the opportunity to raise a formal complaint, which does absolutely go to a different team. They will always look at any complaint, whether it's about a claim or any other kind of circumstance. They'll look at it independently. And then, of course, there's external dispute resolution panels as well, including AFCA and so on. When we have seen complaints go to AFCA, which is the tribunal for financial services complaints, we have a very low turnover rate. So when they look at the complaints, they mostly find in favour, if you like, of the decision that was made.
Okay. Maybe you could, on notice, provide us with a little bit more information about the complaints numbers and how that sort of plays out.
And can I check too?
Yeah.
So there's two types of claim. There's the initial claims, which of course can go through that process, and then there's also the retro invalidity claims. So I take it that you'd like it on both?
Yeah. I think there's a lot of issues been raised about the retrospective scenario. I might turn to the defence guys now. There seems to be a lot of different opinions about what is a defined benefit and the difference of it, and what is the more common accumulation type scheme that we see now. And obviously defined benefit schemes come with risk and reward, in the sense that they are stable, you are guaranteed money, but then you don't get the kind of gains that you might in an open sort of super scheme. Do you want to just step out the differences for the record from defence perspective on, obviously you've now moved to the different scheme, which is much more reflective of where people are these days. So it is an accumulation, and you provide, is it 16.4, yep, which is above the super guarantee.
Which is 12%.
Yep. Which obviously reflective of, the challenges that our defence personnel face. But can you just step out for me those things? Start there.
No, thank you, Senator. I mean, I think as a theme there has been confusion around defined benefit schemes, the nature of portability, that's clearly an evident factor in evidence provided today. I would say, starting off, historically the rates of superannuation benefits for the ADF over the course of the schemes and their contributions have mostly surpassed the majority of other working Australians. The current scheme, which shows how it's moved to a contemporary model, has choice, has flexibility and has portability because it's an accumulation scheme that's been available for all members since the 1st of July 2016. The contribution rate of OTE, official time earnings, is 16.4%. That is well above the superannuation guarantee for regular Australian workers, which is 12%. It is above the 15.4% for the rest of the public service as well. We would hope that that is a recognition of the unique nature of ADF service, in the same way that the cover is provided to all members, serving members as well, and ADF cover is provided by the employer defence. We wanted the contemporary nature of the new system, as again you see in the evidence, hasn't raised as much thematic issues across the course of this inquiry, because it is contemporary and largely working as intended. The fact that that rate is higher is important recognition. We would also say that the employee value proposition for the ADF, we like super to be part of the way people see serving their country and joining the ADF, that's a contribution for that as well. It should be seen as recognition and part of the overall employee value proposition for members.
Now, there were some, obviously the more grandfathered schemes are more problematic in today's world. I mean, they're not alone. I think there was a sense earlier that they are alone. They're not. I have one that I can't contribute to, and I can't take it out because it is old, and it's very frustrating. But I suppose that's just a nature of changes in legislation and grandfathering scenarios.
And maturing and evolution over time. And you see that with the number of reviews into superannuation over the course of the past, say, 50 years, and how the different schemes, the way MBS is different to DFRTB, for example. What contemporary changes occurred then?
The nature of the whole scheme design was based where society was at when it was designed. And I guess just to add to the points provided by Mr Blackman is, the DFRTB scheme was based on a 20-year service sort of model where you'd get your pension after 20 years. When we transitioned to MSPS, which I'm a member of, that changed to 55 when you could access your benefits. So I guess it just reflected at the time, but those defined benefit schemes have a different, attributes than the accumulation fund. Clearly, we're in a world now where there's more choice. People can go in and out of an ADF career, and that's what we want to support. The older scheme supported and tried to attract people to stay in the career longer. So
hence why you got more the longer you stayed.
Absolutely, and that's why the 20-year model was there, because they wanted people to serve 20 years. And MSBS had a similar sort of design. The greater benefit is on the longer service. The current design recognises that uniqueness through a higher contribution rate, but people have portability so they can come and go. And that reflects the change in society where people have many careers.
So with the newer scheme, can people leave the ADF and still contribute to it? Or do you...
Yes, they can.
You can?
Yes.
Okay.
Yeah. And
handy.
If I could add one other element. If a person leaves the ADF, takes on new work, continues to contribute to the scheme, they can purchase insurance through it. So we've
Because that was going to be my next question, because something that really sort of triggered for me was this notion that if you have had claims while you've been within the service, which is, obviously it's a high-risk environment, so that they then, if they moved into a civilian job, they were blocked from getting that kind of insurance.
I won't talk for the whole super system, but you would typically find that there may be some level of exclusion or loading, so premiums get loaded or you get excluded for certain types of injury potentially. With ourselves or through ourselves with ADF cover extension, as we call it. So ADF cover is when you're in service if you're injured as part of your ADF super membership. You get the outcomes that you should be able to receive through an insurance claim or insurance type claim. But ADF cover extension covers those people for their next job, and all of it comes via CSC. And part of the reason for that is if somebody turned around and said, I had an accident, I broke my leg, I was on a building site, that cover, that ADF extension cover, is managed and they're paid for through our relationship with AIA as a commercial insurer. If they said this goes back to my service history, we treat it as though they were coming to us because of their service history and they get cover via the government promise.
So if you're in one of the older, less glorious schemes, for people's impression now, as opposed to what was seen as quite shiny previously, and you can't get cover for, in the super you're in the job you're in, can you apply and get into the ADF cover extension or whatever you called it?
There's complexities to it depending on where you work and those type of elements. Part of the challenge that we have at CSC is you can only join if you're a member of the public service or the military. So depending on, if a person left defence and moved into public service, they would have a PSAP scheme. That's the contemporary PSAP product. But if they were working in kind of private industry or those type of things, they're not allowed to join as a new member, if you like, our contemporary schemes.
So that sort of has a negative impact on someone from one of the older schemes if they can't get that kind of insurance in the job they've got now? Is that what you're saying?
They can still buy insurance. It just may not be through their superannuation, and then
No, but I think what we're hearing is people who have had a number of claims while they're within the service through DVA, then go out into civilian land, and they are, and they're either their premiums are unreasonable or they can't get the cover because of the claims they've made.
As I said, I don't want to speak for the whole industry, but there could be those circumstances.
I wonder if on notice you would just unpack that for us a little bit.
Senator, if it helps as well, typically my understanding is that there are products available which will exclude any medical issues from service, because that will be covered by DVA and the previous cover anyway. So that would allow them to have forward cover, if that makes sense, but excluding any service-related injuries.
So similar to the cover extension that I mentioned, if somebody came to us and said, have got a current injury from my current job, they would be covered in that circumstance, but they would be excluded or potentially excluded for the things that happen during service, and they would be coming back to us for those kind of issues.
Yes.
Okay. If you could just unpack that a little for us, that would be really, really handy. A couple of other... Chair, I know I'm soaking up time here. I'm just going to keep going until I get to the end of my list, or you stop me, one or the other.
Go ahead, Senator Lambie, you've got questions.
Yep. Okay, well...
No, go ahead, Senator Grogan, or do you want to...
I've just got a few.
Yeah,
well,
do you want to...
Senator Grogan, and then we'll go to Senator Lambie.
Okay. Okay, the reservist issue. Now, they don't pay tax on the income they get from defence, but they do not get super. Can you take us back to the rationale for that?
Correct. So if it helps, there's two acts which are operative, which is why there's a link. And just for the committee's reference, there's been numerous reviews into this, and the link is always there between tax-free and no superannuation. So the Superannuation Guarantee Act of 1992 and the Income Tax Assessment Act of 1997 are very clear about the linkage between tax-free income and superannuation. So while reserve income remains tax-exempt, superannuation is not payable. So there has been a clear linkage between those two positions for some time. And as I said, various independent reviews have considered that relationship. That includes the Nunn Review and the Podger Review, and both recommended that introducing superannuation for reserve members needs to occur alongside the discussion of tax-free pay. In the previous evidence given to this committee earlier, we hear from ADF members both ways about what's more attractive, being tax-free or having superannuation. It's a mix. On balance, we probably hear that tax-free suits members better overall.
And is that because they would be taxed at a second job rate if they were working elsewhere?
It depends on the nature of the circuit at which they come back, but a lot of former permanent ADF members then join the reserve, and the tax-free status suits their circumstances. And reserve pay fundamentally is not primary employment.
It's defined as not. It's defined as such.
It is not. It's not intended to be the primary employment. And you can, of course, make super contributions from that income. You could top up your own superannuation while you're earning a tax-free reserve remuneration.
And the only time it is paid is when they're in continuous service. What does that continuous service mean? Because if you're still a reservist, is it that they do stretches for what sort of period of time? What qualifies?
Would depend.
So Senator, they essentially changed the nature of their work to full-time work. So although they still were a reservist, they go to continual full-time service and they get treated as a full-time member, which means they get all the conditions that a full-time member would get: housing subsidy, pay tax, etc. So their conditions flip to a full-time member. Generally, it's for a period of time, so it might be a continuous full-time service for a contract for a job for 2 years, for example.
And they are paid superannuation during that point.
And are they then sort of transferred to sort of defence pay scales, or are the reservists on? So
there are pay scales for the full-time and part-time force. They're based on the same annual rate. The only difference is the reserves has a divisor, so it's divided by 365 to get the daily rate.
Okay. So, because my concern is that the reservist rate is then below the defence rate, and then to make up for the tax-free.
It's complex. It's complex because the full-time member pays tax, and clearly the tax-free status the reserve pay. There is a point where if you parade, you work many days as a reservist, you're actually better off because you're not paying tax.
So you're not getting any super either, but you are if you're a continuous.
Absolutely. If you're on continuous full-time service, you are exactly the same. You're treated the same as a full-time person.
So you pay tax?
You pay tax.
You get super?
You get super, etc.
Okay.
It's only the person who's parading on what we call days, so a pattern of weekend service, weekend weeks, etc.
Okay, thank you.
Shall we move to Senator Lambie? Senator? Right, I'm conscious we're wrapping up in 15 minutes.
Sure. Can I just put a couple of quick things on notice then?
Please, yeah, why don't you do that?
I'm interested in the harmony or lack thereof between the Defence Force, CSC and social services.
Oh, great. I'll wait for that answer. Sorry, I'll wait for that answer. You go ahead.
You know, I think a lot of us know how difficult it can be for people to navigate their way through bureaucratic services of any shape, size or description. But what we hear is that they're having to navigate through, and there are contradictions and negativities in the interface between, you know, Defence, CSC, social services, DVA. ATO. Yeah. Yes. Don't know how I forgot them. But that sort of challenge, is there any work undertaken to harmonise that? Is there a way we can make things easier for people? In many of the social services areas, there's a move towards this tell us once theory, where you don't have to start from scratch every time you go to someone. Is like what's happening in that space to try and assist our defence members and ex-defence members actually get the services and the supports they need in a manner that isn't going to drive them nuts.
We can come back on notice. There is single door principles that DVA have, along with CSC and others, for that exact reason. And obviously we put a lot of effort into better education at transition points, even our own ADF pay and condition websites, where we give information to new recruits, ADF, and then when they're in transition for them and their families when they depart the ADF. There's a significant education piece we know, and we're working very hard on because we know the complexity is there. We work with CSC as well on that education piece, so we'll come back and on notice some of those efforts as well.
Thank you. And the only other two things I've got, and I won't go into them because I'm absorbing everyone's time here. Why is the indexation different for different things, and why are there tax inconsistencies? Thank you. Thank you, Chair.
Thanks, Senator Groden. Senator Lambie.
Thank you. Thank you for that. I just want to come back to ComSuper. If you can... so I just want to talk about this insurance that you've got going on. So if we take out insurance, correct? If we're at another job? Are they there?
Yes. Yep.
Yes, sorry. Where's the insurance? So how's it paid for? Do we paid out our wages? Come out of our super?
Yeah.
I just didn't know if I heard that properly.
Yeah, so for clarity, Senator, a person who has moved on from the ADF and working in another industry, another job, they pay for their insurance through their superannuation, so the contribution goes in, the insurance premium is then deducted from that. This is similar to how most Australians pay their insurance, their life, TPD, death, type insurance. And as I mentioned, it's done through a commercial arrangement with AIA.
Okay, and what's your rate look like, and what's your market rate look like compared to everybody else? Is it around the same? We're paying the same as everywhere else? Is there any special benefits in that?
Yeah, it's a little bit higher than our civilian counterparts, and that's because of the scale differences that when we first set this up, this has only been a feature of that product for about 4 or 5 years. So we only have several thousand people with that extension insurance. I'll take the question on notice and come back to you with the comparative rates between what a PSAP member pays and what a ex-defence person pays.
Okay, and does that ex-defence person pay more if they've got more previous injuries, that sort of thing? Is that worked out in all that?
No.
No. Okay. Okay, so... Okay, and I just wanted to go back to the complaints and management processes that you have.
Yep.
I was just wondering, can you tell me how many, I'm not sure if anyone did ask this, but how many complaints have you had, like how many complaints did you have up last year?
Sorry, how many complaints?
Complaints?
Total for the year includes all of our civilian complaints, so I'll take it on notice and come back so that we separate civilian from defence complaints.
Oh yeah, that'd be great. And whether that's complaints on everything, like they're not separated into a high category, low category. I want everything. Any complaints?
Correct. Under a regulation that we abide by, we're required to measure all complaints.
Right. Okay. And I don't think there's anything else I had. No, that was it. Thank you.
Thank you, Senator.
Thank you for that, Mr. Nathan. That was great. Thank you. I think I do have a question for Defence. Has Defence undertaken any work to determine whether the differences between defined benefit schemes and modern accumulation schemes create inequities across the service cohorts?
Senator,
I just noticed that obviously one is claiming that theirs has lost value.
So what I can add is, obviously we've had a number of reviews and that's resulted in changed superannuation schemes. Since the PODS review in 2007 and the introduction of what is now ADF Super and ADF Choice to change super schemes, there's not been a comprehensive review or comparison of the three schemes that I can advise you of.
Oh, okay, that's interesting. Okay, and actually I have no further questions. Thank you.
Thank you, Senator Lambie. Just conscious we're reaching close to the conclusion of the hearing. Senator Dowling, have you got questions you wish to ask?
They can probably go on notice as well because they follow what Senator Grogan was asking around indexation, because we heard earlier that that's a really significant issue. So I just wanted to confirm precisely which components of ADF pensions are indexed, which are permanently excluded from indexation across both the DFR, DB and MSBS. So effectively, I want to understand if two veterans with the same service can see their income diverge over time purely due to the indexation structure.
Copy. We'll take that.
Be happy to take that one on notice.
Yeah, thank you, Senator. We'll take that on notice. Thank you.
Thank you.
Okay. Well, we are almost at 4:15. So if senators are happy to put any further questions on notice, I do propose
Can I just have one more question? Sorry.
Yeah, we've got 10 more minutes, Senator Lambie, to go.
Right. I just have a quick question for CSC. I'm going to put some more on notice about this, but do you know anything about reporting a $0 tax-free component when veterans' payment summary clearly show they have a tax-free component as derived from tax? Do you know anything about that?
I heard about it when I was sitting in the room here earlier, Senator.
Okay, do you have anything to do with the Centrelink, whatever? Do you have to answer any of them? What forms? Do you have to tick anything for Centrelink, any of that sort of stuff? Why don't you run us through that?
Yeah, there's a whole range of different agencies that we supply information to. It's typically not in a form but in a data file, and those files are established for us in what those different agencies require, and so we build into our systems the ability to supply that information in the right way. If there's differences, we haven't heard about it, or I haven't heard about it.
Okay. Okay, no problems. Thank you very much. I'll do some follow-up ones for that, but thank you so much for the answer. Thank you. That's all for me, Chair.
Thanks, Senator Lambie. Well, thank you to Defence and CSC for your appearance today. That does conclude today's hearing. Thank you to all the witnesses who appeared and to Hansard and Broadcasting for their assistance. The committee has agreed that responses to questions on notice should be provided by the Thursday the 5th of March, which is 2 weeks from today, Thursday the 5th of March 2026. And the committee now stands adjourned. Thank you.
Thank you.